practice of this court is that we call page by page and thereafter we take up these matters not in the list.
I'm
Just a moment.
I'm
Yes.
from out of the board.
Just wait for a minute. It will not take much time.
Page number 1, item 1 to 4.
Go on.
Page number 2, item 5 to 9.
My lord, I may be pardoned. Item number 5, my lord.
Yes.
My lord, I pray for one adjournment. This is a fresh application, but I have some difficulty today, my lord. Only praying for next week, my lord.
You're going to argue it?
My lord,
You are the arguing counsel.
my senior is the arguing counsel.
You said you have some
I'm
difficulties.
my power is there, my lord.
No, who's going to argue it? Because
Lord,
you said
Mr.
you have
Das.
some difficulty. Okay.
25th.
We are fixing it on 25th of July.
My lord, obliged.
You are Mr. Sushant Kumar Das.
My lord,
No,
I'm
no,
on behalf. I'm P. Das, my lord. My
P.
power
Das.
is
The
there.
request of Mr. P. Das and counsel appearing for the appellant. The matter will be listed on 25th of July 2023. You please inform the counsel for the
My lord.
respondents and also the caveat. I do not know whether they are the same persons or not. Yes.
Lord, okay.
Page 3, item 10 to 13.
I'm sorry, my lord. Item number 6, page 2.
Yes.
My lord, in the last occasion, your lordship was pleased to direct me to submit translated copy of English version
Mm.
because
No,
of
no.
my eye
Translated copy of the Oriya text. Whatever
Odia text, my lord.
Ah.
Because of my eye infection, I could not be able to do so. Let
If-
it come
if-
next week
if-
or
if-
any day, my
if
lord.
you fix on 25th of July, is it would be able to
My
do
lord.
that? Okay. At the request of Mr. Arun Kustil and counsel appearing for the petitioner, let the matter be listed on 25th July 2023. In the meanwhile, the translation is asked by this court be submitted.
My lord.
Page number 4, item 14 and 15. Page number 5, item 16 to 19. Page number 6, item 20 to 22.
Item 22, my lords. I am for the petitioner, my lords.
Yes.
I pray, my lords, I'm preparing a date chart. I could not complete it, maybe taken up any day, my lords, next week, my lords.
31st.
No entry, my lord.
It will be taken up on 31st of.
To these honorable single judge, my lords,
Hmm.
this, my lord, the lordship may kindly see page, my lord, 52. Honorable single judge order, my lord.
Yes.
Where the honorable single judge, my lord, in fact, it has page 53, deciding that the Sarat Chandra Tripathi case, as per the Sarat Chandra Tripathi versus Orissa Forest Development Corporation case, my writ application was rejected, my lords. But here is a case, my lord, the Sarat Chandra Tripathi case is not applicable to my case at all, my lords. Because why, my lord? The Sarat Chandra Tripathi case is the own set of rule, my lord. But here, my lord, as per the Orissa, my lords, at placing the rule, my lords, the Orissa Housing Board rule, my lord, the rule 5 subclause 3, my lords. Here I may permitted to place the rule, my lords. The service rule is regard to age limit, leave allowances, discipline, conduct and retirement benefits, including pension and seniority, applicable for time to time to the government employees, shall apply to the officer and employee of the board. But
The government employees retirement age is.
yes, my lord,
60
the
years.
turn to page 20, annexure 1, my lords. The state government has issued the resolution on 28 June 2014. Here, my lord, the enhancement of retirement age on superannuation of state government employee. After this resolution matter, my lord, all the corporation throughout the state, my lord, comply the order passed, resolution passed by the government, and the enhancement is 58 to 60, my lords.
But the housing board is not a department of the government.
No, plus the applicable because housing board.
So
Because
it is the board will decide.
Well, let's,
Board
yes,
will decide.
board
With-
after
with-
decision.
With prior approval of the state government.
Yes, my lord. Prior to approval of the state government. My lord, the board pass and resolution, lordship may the order, each lordship may that
Have you quoted anywhere these housing boards, these rules that you have right now read out to us?
plus I have it was referred to the order passed by the single judge also, my lord. I am passing it over, my lord. If you
No, we want to see the text of the rule, not the reference of
I'm
the
sorry,
rule.
my lords. But if your lordship may,
You just show us the. Kuntiya, what is the difficulty? Because their rules provides this as per the, let them consider it.
Yes, my lord, what has happened, my lord, state government has adopted 60 years in respect of government employees.
Yes,
Thereafter, board had to accept it as the matter of principle in respect of the employees of board, that 60 years.
yes.
Since the board has not taken the decision, so it is the 58 years the age of.
Still continuing, but just seeing the board, this rule says all service conditions. which
Yes,
are
yes,
not
I have seen that,
will be at par with the government employees.
my lord.
So government has changed 58 to 60 years.
68, my lord. Step 60.
Anyone is appearing for the board here.
Board, we are not.
Usually, madam. So usually I appear for the board, but so far my knowledge goes 58 years, means earlier it was 58 years. Subsequently, pursuant to the decision of the board, government has made resolution that yes, it will be 60 years. Accordingly, those who are continuing, they will continue up to 60 years. They retired after attaining age of 60 years.
This is the case he has read.
From 28/6/2014.
Probably
yes,
by
sir,
that time.
2014.
But
After that, I have.
But you have retired in 2014.
Yes,
It was
Yes, my lord. 2014, after the resolution of government, 20 August 2014, it was page 45, annexure 4, my lords.
Page 45.
Yes.
Mr. Mahapatra,
Yes.
are you in a position to make your submission today?
I don't know, I have not got in whatever pleadings and all this.
If
Because
you
in
fix
the
the matter,
meanwhile,
because it is very small issue.
Yes.
in the meanwhile, 3-4 set of judgments have passed minors. Referring to Cuttack Development, decision concerning Cuttack Development Authority. Of course, I got a
I
privilege.
think those judgment cannot, expressly will apply this case because I'm telling you, that there may not be such rule in those organizations.
No, these judgments, that was applied, but these judgments, the Honorable Court held that it will be up to 60 years.
Already.
Accordingly, 60 years criteria.
If you keep the matter on day after tomorrow, would it be
Day after tomorrow, I will not be there. Tomorrow, on Thursday,
Thursday?
Thursday. Let him serve a copy
Yes,
so that.
I'll in course of
You
it, I'll
serve
serve.
the copy.
Yes, in course of it. But here also these.
Probably, what I understood, all
You
those.
come prepared with all the judgment. that
Yes,
you're
yes,
saying
my
that the judgment in your favor.
Yes, yes, my lord. Because, my
Alright.
lord, here this honorable court.
So I will
also state-
reflect that you are receiving notice for this board. Heard Mr. A.N. Patnaik and counsel appearing for the appellant admit and issue notice. Notice is made returnable on Thursday, the date 20th July 2023. Since Mr. M.K. Kuntiya, learned additional government advocate, appears and waives notice for the opposite respondents number 2 and 3, and Mr. D. Mahapatra, counsel, appears and waives notice for the respondent number 1. No formal notice is called for. Mr. Patnaik, learned counsel, is requested to supply a copy of the memorandum of appeal with all enclosures to Mr. Mahapatra in the course of the day. Stop. On the next date, there shall be an attempt to hear the matter on merit.
Thursday, Thursday.
Thursday, 20th July.
Grateful.
Item 2.
Yes. Oh, okay.
Item 2.
You call it 2 again. You're going to dismiss this writ petition. Last occasion also, there is no representation. Yes,
Item 3.
yes, Mr. Malik.
Yes. I challenge my lord in this appeal
The in order of the Honorable Single Judge, remanding the it's a punishment in the Department of Proceedings dismissal, remanding for the second time, my lord. First it was remanded, and the first order, Honorable Single Judge,
Where is the learned single judge's order?
last at page 83. At page 83.
Yes.
Let's turn to last page 101. 101. Earlier it was remanded, directing the dismissal to conclude the proceeding within a period of 3 months.
Yes.
They did not do it. Therefore, after 3 months, my lord, the dismissal proceeding lost its jurisdiction, my lord. He continued to continue the proceeding after 3 months, my lord.
So you want that the proceeding shall be declared?
Yes, madam, because now it is futile. From the evidence recorded, they have remanded to the stage of defense witnesses, my lord. Prosecution witnesses have already been completed. From the prosecution witnesses itself, my lord, no charge is proved against me, my lord. From the prosecution witness, no charge is proved.
So you have filed this written statement at this stage? No.
No.
Because I think the Orissa, the disciplinary proceeding rules is like the CCA rules.
Yes, madam.
Almost there is certain variation is there. So there is a provision that if you find that there is no evidence against you, can file an application for discharging you from the charge to the inquiring authority.
Yes.
Already we'll examine the matter. Who is you are appearing?
Yes,
Fixing the matter on 21st.
of this month, my lord.
Uh,
Next week, any day.
Someone is suffering, either this or
Yes.
that way, that may be decided.
Yes.
For
Next,
final.
next week, any day.
Next week.
Madam.
Next week, which date?
27.
27th of July.
Madam.
Okay.
Administrative Judicial Molecular Council. Appealing for the appellant by means of this intercourt appeal. The order dated 31/10/2022 delivered in WPC OSC 3857 of 2017 has been challenged. So, the fundamental grounds that has been taken that despite the failures in terms of the order placed in the previous writ petition, when a single judge has remanded the matter again, even though the records of evidence so far, record of evidence would show that the misconduct that has been imputed by the charge memo has not been established at all. Admit issue notice returnable on 27th July 2023. Since Mr. M.K. Khandial, an additional government advocate, appears in web's notice for the respondents. No formal notices called for. ST is directed to place the records of WPC OAC 3857 of 2017 with these appeal records. On the next date, there shall be a serious endeavor to hear the matter on merit.
Item
Yes.
4. Item 4.
I may kindly permitted, my lords.
Yes.
This writ appeal has arisen out of the judgment and order dated 1st May 2023, passed by the Honorable Single Judge in WPC number 9850 of 2012.
Yes.
The crux of the matter relates back to the year 2000, my lord. What happened in that year? The Bhubaneswar Development Authority, who is respondent in this case, had floated a residential plotted scheme that is known as Prachi Enclave Development Scheme. and fixing the last date to 4/10/2000.
Yes. Then,
In that scheme, my lords, there were a total 148 plots, and out of those plots, 10% of the plots, that is 15 numbers, were reserved for allotment under the discretionary quota of the minister.
yes,
So 15 plots came out of 148. Then for the rest 133 plots, there was a reservation for SC, ST, then defense personnel, ex-army,
yes.
and also 2% for the staff of Bhubaneswar Development Authority, who are under regular establishment. This writ petitioner, who is now the appellant before your lordships, he was also an applicant under the BDO staff quota, and along with him, 12 others were also the applicants. Since the allotment of the plots were to be made through lottery, one lottery was held on 27th December 2000 under the supervision of one retired honorable judge of this honorable court, and the 133 allottees were identified in that lottery. And in that lottery, since there were 3 plots reserved from the BDO staff quota, the present appellant along with 2 others, Mr. Ambika Prasad Mohanty and Mrs. Pratibha Baske, they were also allotted in this lottery. Thereafter, what happened, my lord? These total 148 plots were put for another lottery for identification of individual plot numbers.
Yes.
That was held on 11th June 2002. And in the second lottery of 11th June 2002, plot number 108 came to be in my name.
Yes.
But after the first lottery of 27th December 2000 and before the second lottery of 11th June 2002, some Benami complaint was filed before the Vigilance SP Bhubaneswar on the allegation that this writ petitioner, present appellant, had been allotted with a plot that is a commercial plot in district sector Chandrasekharpur. So how this residence plot came to be allotted to him? On that allegation, my lord, an inquiry file was opened. The superintendent of police, Bhubaneswar Vigilance Division, called from the records from the BDO office. The officers were noticed to appear, and after scrutiny of the statements of the BDA and also the concerned brochures, the Vigilance SP came to the conclusion that allotment of a residential plot in favor of Saroj Kant Malik is found to be not irregular. And that vigilance report came on 29th September 2004.
It will be appearing in this matter.
Yes, I filed that reply.
Only issue, Mr. Mahapatra, is that first on the commercial plot.
No,
Is
minister.
the-
There are some set of additional fact for my lord's consideration. Initially, he got a residential plot.
The 262 is a residential plot.
No, these are all residential plots.
No,
But-
262 is a commercial plot.
No,
That is
260
what, no, his contention is that 262 is a commercial plot.
plot number 262.
Ah.
It is a commercial plot.
Hmm.
I am
So
not.
he
on that.
applied for a residential
No,
plot.
no, sorry, my lords, with due humility.
And BDO also provide.
Just a minute.
All right, let us see. This is
I
the
will-
issue.
I'll tell 3 sentences. Then my lords, 3 propositions only, nothing more. Now for the time being, my lords. Fact remains, my lords, he was initially allotted 1 plot, residential plot under a scheme. Initially in the year 1991-92.
Not the plot number 262.
No, before that. He sold the plot, taking permission from BDA, he sold the plot. Thereafter, he wanted to purchase that plot to third-party transfer, which is a leasehold plot of the BDA. It was given to somebody. He filed an affidavit, wrong affidavit, disclosing therein that I don't have any other plot or I have not sold any plot. That is what the commercial plot was allotted. But also permission was allotted to transfer that plot in their favor. Now he is in possession of that commercial plot. It is in a very posh locality, and he is in use and enjoyment of that plot. Then my lord's Prachi Enclave residential scheme came. He again applied another plot under that scheme, that too under 2% discretionary quota. Well, discretionary in the sense 2%, not for discretionary quota, 2% for the BDA employees.
But according to the learned single judge, in your scheme, there is no restriction clause at all.
No, there is no restriction clause in so far this
Yes.
is concerned.
Huh.
But our Honorable High Court held in a division bench, these 2% criteria fixing allotment is bad. That is the decision of our division bench, decision of our Honorable High Court. That was not brought, right or wrong, this was not reported.
But
that right.
15% discretionary quota is not bad.
Well,
15% discretionary quota is not bad.
Almost that judgment my learned friend has given, and that judgment is there. All these discretionary quotas were held illegal.
We will take up the matter on 20th July. Please come with the full instruction.
Well,
Show us the original scheme also that we floated. All right.
My lord, they are
Well, so
going to
now
auction
thing
that
is-
plot on 26th
I
July.
am coming to
So
that.
I am taking up the matter on 20th July, Learned Council. Why you are expressing
My
anxiety?
lord, they are taking time since the very beginning of the filing of this petition.
I am not taking
That is
time,
why
my
this
lord.
matter has been delayed to this
I am
stage.
not taking time, my lords.
My
No,
lord,
he's not taking time.
My lord,
but
I am just
later he
pointing out
immediately
one thing.
agreed to a proposition.
my
This
lord,
clause is put into action only. I am to point out one thing.
Now, on 20th July, we'll take up the matter for
But-
disposal.
What do you
There,
want
my
to
lords, I-
point out? What?
Yes.
No, you said you wanted to point out something.
Yes, madam. The point out is, madam, this notification my learned friend pointed out that auction. There the base price of that particular plot 200 to 2,400. That is, my lords, bigger size plot in Bhubaneswar, 1 crore 20 lakhs.
So you are saying if you put it to auction, at least the price will be known.
No, I am not on there.
Then
Kindly visualize one thing. Then it was 1 lakh, 2 lakhs for 40,000. Now the price, commercial plot he enjoyed.
No, he
Residential plot is sold.
he doesn't suffer any disability in the process.
My lords, right in that respect.
Yes.
Fact remains, once somebody got a plot, commercial plot,
Show that creates a restriction, that's all right.
I will bring that judgment. I will
All right.
also.
Heard Mr. P.K. Tripathi, Land Council, appearing for the appellant. Admit, let the matter be listed again on 20th July 2023. So we also request Mr. D. Mahapatra, Land Council, appearing for the Bhubaneswar Development Authority, to bring the scheme called Prachi Development Scheme. What is this Prachi?
Enclave, Prachi.
Prachi Enclave plotted development scheme.
Prachi Enclave
Plotted development scheme.
Plotted Development Scheme
Plot number 108.
for examine whether there is any restriction under the 2% quota. Stop.
I will also submit, my lords, the judgment of the Honorable High Court.
No, you submit whatever, we have opened it. This matter will be heard on that on merit without accommodation without further accommodation. As Mr. Tripathi Land Council has submitted that the date for auction for the plot under reference is fixed on 26th of July.
26.
26th of July. All right. 20th July it will be coming up.
20th. My lord, I will just point out one thing, but Mr. Lawn Friend submitted that I have sold one plot. That is entirely wrong. That plot was transferred on pre-possession basis, and that order also was cancelled, and that plot is still in the possession of BDA.
No, my lords.
I will show the document, my lord, at the time of hearing.
Documents are definitely part of the writ petition.
Yes.
All right, all right.
And that is also admitted by them.
Petition may be also brought in record so that will show.
This list is directed to place the records of this is item number.
4.
Records of WPC number
9850.
Writ petition number
9850.
9850 of 2004.
2012.
There, it's there.
My lords, fixing it, my lords.
Yeah, it is already there.
Fixing it, my lords.
48.
Yes.
9850 tag.
Screw out that line, just not there.
My lord,
because
that
they've
has
placed.
already been tagged
It is
9850
right
along with
above.
earlier
In
writ
compliance
petition
of our last
852.
order. All right.
Item 7.
None appears for the appellant when the matter is called out. Let the matter be listed again on 31st of July 2023. It is made absolutely clear that there is no representation from the appellant will be persuaded to pass an order of non-prosecution. Next.
Item 8.
Last occasion, my lord, and government advocate taken time for taking instructions for the time. Madam.
Lordship, the last order, my lord, it was fixed to 12th September.
12th September.
Yes, my lord.
Last order is 15/5/2023 only.
15th,
5.
yes, my lord.
15th of May.
15th of May 20. It isn't fixed to 12th September, my lord. If your lordship will take up this matter next week, I can take also instructions.
Let it be listed on 20th July 2023 at the request of Mr. M.K. Kunthial and additional government advocate appearing for the respondents. Mr. Siddhesha Malik and counsel is appeared for the appellant. 20th July.
My lordship fixed it to
20th of July.
next. I am praying for next week, my lord. In
Next week. 27th of July.
my
26.
Item 9.
No, please, my lord. On the last order, we were directed to remove the defects that
Yes.
we have done. List of dates have been filed.
On the last
On-
occasion, you took time for preparation of the argument,
Yes, my lord.
not to remove the defects.
Pardon, my lord.
Last occasion, you sought time from this court for preparation and to address.
Actually, yeah, we are ready. with matter, my lord.
All right, if you're ready, you address this court. Who is appearing for the
Yes,
state, Mr. Kuntia?
I-
Are you ready for the final?
copy not served. Only IA copy is served. Let him serve a copy.
IA was for the
That
condemnation.
one,
That is the defect.
writ appeal.
only IA copy, IA number 2801 of 2020 for condemnation of delay that.
So I think you will not oppose these 14 days condemnation.
No, well, real or some
All right.
14 days delay.
Writ appeal copy, they have to serve.
Or after condemnation, you are directing them. You are Mr. Paul?
Pal.
Yes. And your name, sir?
Kishore Kumar Patel.
Patel.
Patel
Appearing from who?
You are appearing for the appellants with
for
him.
the appellant.
Okay. Mr. Kishore Kumar Patel. Learned counsel. Along with Mr. S.K. Pal and counsel appears for the appellant. Stop. The applicant, huh? This is an IA. Read. 2801/2023. This is an application under section 5 of the Limitation Act for condoning the delay that occurs in filing the intercourt appeal. From the common judgment. You are filing that against the common judgment?
Come on, judge.
Common judgment dated 17/8/2022. Delivered in WPC OSC number 2645 of 2014. Stop. Mr. M.K. Kundial and counsel appearing for the respondents is clearly stated with the threshold that the respondents will not, opposite parties will not oppose the prayer for condonation, considering the short length of delay. Having recorded the said concession, the delay stands condoned, and the result, this application is allowed and disposed of. Now you come to the main appeal. In view of the order passed today in IA number such and such, this appeal is taken up for consideration. You have not also filed the certified copies.
Certified copies.
You have filed already?
No, my lord. I'm applied, my lord.
So you file the certified copy, you take up the matter later on. Then the matter will be listed again on 31st July 2023. In the meanwhile, the appellant shall place the certified copy on record. Stop. Stop. The Learned Counsel of the appellants is further directed to supply a copy of the memorandum of appeal with all enclosures to Mr. M.K. Kunti, Learned Counsel, in the course of the day.
Yes, I impossible.
My lord, I have prayer because this case went to DB also. So the writ number 8877 of 2017, that may be kept in the court for perusal of my lord.
Let on 31st the matter be taken up because it is not very difficult to bring the records in the same court.
Or if you want to direct, I can Xerox it.
You are at liberty, you can file it also. All right.
Item 11.
You just file the certified copy first. Otherwise, you have to take up that application for
Yes, yes,
dispensation that we don't like to take up. We don't understand why the certified copy cannot be obtained. You just apply for the certificate.
In the meantime,
Right.
I'll file.
All right.
Item 11.
Beg your pardon, my lord, I missed out item number 7, my lord. My lord, no instructions. Item 7, my lord.
So we'll dismiss it right now.
My lord,
We'll dismiss this appeal right now then. You have no instruction.
Who are you?
liberty may be granted for some time.
Huh?
We'll contact the,
We have fixed the matter on some 31st July. You come on 31st July. Yes.
Item 11.
Same order, none appears. There's just like earlier order, no? Will be pursued to passengers and such. Next.
Item 12.
Item
Item
12,
11, have you received copy? No, not served copy.
Item 12, I am appealing for the respondents.
item 12, my lord.
Lordship, look at your lordship's order dated 19/5/2023.
I am submitting that. Lordship, that last order 19/5/2023. Lordship has directed me to take instruction whether that amount has been paid or not.
Item number
12, my
12,
lord.
okay.
2 days time, my lord, that instruction has not come. Your lordship may fix it to day after tomorrow. I will take instruction.
Mr. Mishra, all right, day after tomorrow.
My lord, 8 years I have been suffering not getting the retirement benefit. 8 years.
All right. Mr. M.K. Kuntial, an additional government advocate appearing for the respondents, has submitted that in terms, appellants has submitted that in terms of the order dated 19/5/2023, could not obtain the instruction. Stuff. He needs a short accommodation. Please stencil out. Let the matter be listed on 19th July. Day after tomorrow. 20th. 20th July 2023. Mr. KP Mishra, Senior Counsel, who is assisting you?
A Mishra, my lord. A Mishra.
Mr. A Mishra, and Counsel appears for this respondent.
Your Lordship, item number 11, I was coming from Deputy Registrar to this Honorable Court in order to list out the matter. Item 11, earlier I had already submitted before the, in order to take time 1 week, day after tomorrow. Day after.
It will be coming next on 31st of July.
No, Your Lordship, delayed, being delayed.
What?
Being delayed.
The date is long.
Against a single bench order, writ appeal. But due to
You are not there. We have passed already the order. It will be listed again on 31st July. Come on 31st July. All right, we'll consider on
Your
that
Lordship,
day. Please.
Your Lordship, okay.
Please maintain the decorum of the
Your
court.
Lordship, 30.
Yes.
Item 13.
Item 30.
Yes.
Item 13, we are the petitioner, my lord. Last occasion.
You are petitioner or the appellants?
Yes, sir, appellant.
Okay.
Against the order of the judgment, we are before my lord.
Yes.
This here is the case. This some misappropriation there. Last occasion, my lord, remember that about the CBI matters. We sought for instruction. They are obtaining papers from the CBI office. Then only my lord will enlighten the court. So lordship will give some more time.
Are you fixing on 31st July?
Yes, ma'am. Yes,
At the request of Mr. P.K. Padi, Deputy Solicitor General of India, is appearing for the appellants. Let the matter be listed on 31st July 2023. With the next date, the record instruction be taken. No further accommodation be made for the same purpose. Okay.
Obile.
Item 14,
May I please, your lordship? My lord, in this case, my lord, I have filed it in the time, my lord, before limitation. But it is pointed out that a limitation petition, if a lordship go through the page 156, the impugned judgment, my lord, passed on 8/5/2023.
Just a minute. Give the physical copy of the record. They have not done the essay. Not the provision. This essay has not been done. Essay not required. This is not the same. This is the item number.
Noting taken doon sir, any noting taken down पर नहीं. It is the file.
The step reporter's report shows there is a delay of 30 days. Because your filing of the certified copy, that period has been now added according to the rules.
Well,
To file a short application for the condonation of delay, let the matter be listed on 10th of August. In the meanwhile, the appellant may take the appropriate steps for condoning the aforesaid delay.
Stamp report may be scanned.
my lord, can I frame a short date because I am worried about.
All right, 31st of July. Already you just take note and ask them to scan the stamp report. Yes.
item 15,
Your Lordship, item 15 may kindly be passed over, Your Lordship. My learned senior Durga Prasad Nanda is on his legs, Your Lordship.
You are there?
I'm there in the other matters, Your Lordship. Same connected matters.
All right.
I'm appearing on the other matters.
You take up at 2, come at 2,
Lordship.
because Mr. Nanda is not available.
2 o'clock.
Huh? Let it be there. All right. Call the next matter at 2. There are 2 other matters are fixed at 2. So we'll be, after hearing those matters, we'll take up this one.
So this would be taken up first and thereafter. No.
No, this will be taken
The
up
other
later
way.
because these are the fixed matter by order.
Lordships.
All right. You keep one of your associate, they will inform you.
item 16,
In this matter, I'm challenging the Order of the Honorable Single Judge, my lords. In my lord, in which in the writ petition, I was challenging the order of recovery from my gratuity amount after the 5 years of my retirement, my lords. On the basis that since I had submitted a undertaking that any amount duly recoverable, legally recoverable from me shall be recovered from my gratuity amount. And basing on that, they are recovering. My submission before you lords, while making the undertaking that legally recoverable from me, there was the intention that if any disciplinary proceeding is initiated against me and that it is found that any amount is recoverable from me, then it can be recovered. But without initiating any disciplinary proceeding, they are solely recovering the.
First of all, whether you are given any notice or not. We are not concerned with the recovery proceeding.
My lords, no notice was given to me, my lords.
It is only the giving you the reasonable opportunity, because either you have taken the government's money unauthorizedly, whatever the amount that may be, only you are entitled to a notice, nothing more beyond that.
My lords, they are recovering only without giving me any opportunity of hearing, my lords, and that is again not in consonance with the section 4(6) of the Payment of Gratuity Act, my lord, where it stipulates that it can be recovered only if it is found that it can be recovered under a disciplinary proceeding, not on basis of an audit objection.
Whether the disciplinary word is there or not,
My
we'll
lord.
check out.
But as per your date chart, you have given an undertaking that any outstanding dues can be recovered from your gratuity.
My lord, legally, if any recovery subject to legal, it may be recovered. If it is recoverable legally, then they can. That is the undertaking. My lords.
Because if you have given an undertaking, then it is not necessary.
My lords,
On basis of your undertaking, they have given you the no due certificate.
His undertaking, he says that he has given the undertaking, it is legally recoverable.
What is the meaning of that? That is why
Legally
they give him
recoverable,
no due-
what is the statement?
no due certificate, that is why they have given basis of the.
Lordship.
Just
Dr.
a minute,
Permits, I'll
let
play.
us have the book.
my lords.
Who is appearing for the opposite party, Forest Development Corporation? You are appearing. I simply asked you to whether there is a notice was issued.
My lord.
Because before recovery, whether any notice was issued to the petitioner.
My lord, let him submit. I'll
All
play
right,
that chart.
sure.
I have given a dead chart. Let him.
All right, I've seen it.
This Payment of Gratuity Act proceeding has not been raised before single judge. They come twice before this honorable court. And I'll see the single judge order. And only
I'll see.
file an appeal.
You are referring to?
Section 4, Section 4, subsection 6, my lord. Shall I place my?
All right.
Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful omission, or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. The gratuity payable to an employee may be wholly or partly forfeited if the services of such employee have been terminated for his riotous or disorderly conduct or any other act of violence on his part, or if the service of such employee have been terminated for any act which constitutes an offense involving moral turpitude, provided that such offense is committed by him in the course of employment.
How does it apply in your case? Show us.
My
It says it's after the termination, disability created by way of action.
My lords, the petitioner services have not been terminated. Petitioner duly retired from the service on
So
31/10.
how this provision will apply in your case?
My lords, that since the petitioner services have not been terminated for any of the act they are alleging, so that cannot be recovered from the gratuity amount, my lords. That is my submission.
They are going to recover according to your undertaking.
My lords.
You have just forsaken your right.
My undertaking was that if anything legally
No, that
recoverable.
part we have understood, but
My-
this provision doesn't apply to you.
Well, this provision says that if under this
It is under this provision says there is a three contingencies have been described under this provision. In three under contingencies, what will be the action of the state? So for the recovery from the gratuity is concerned, they have only made the exceptions to the general provision. Right? This doesn't apply to your case. You did not suffer any of the three disabilities. Those have been provided under this section.
My lords, that is my first submission, my lords. Second submission is, my lord, after this impugned order was relied by the in a similar matter by the opposite parties, and there the honorable single judge has negated the impugned order and has extended the gratuity amount to the concerned.
Show us their judgment. Don't make it any submission. Only one copy?
No, well, 2 copies are there.
Yes.
Please, my lords.
Yes, yes.
My lords. From para 5, your lordship may kindly have. On the basis of fact, it appears the petition was admittedly retired from service on attaining the age of superannuation on 31/7/2002, and he has not been paid his retirement benefits of gratuity as well as leave salary as due and admissible to him. Though the gratuity as well as leave salary have been sanctioned by letter dated so and so, the same have been withheld due to the fact that on the basis of the internal audit conducted by the corporation, an amount of rupees 5 lakh some odd in total recoverable from the petitioner, out of which so and so has been recovered. Therefore, the chief audit officer submitted a report on 3/5/2005 showing an outstanding of rupees 5,20,000 some odd. Since the triangular committee has not finalized the audit report involving recovery of rupees 5 lakh some odd, the sanctioned amounts such as gratuity as well as leave salary have not been released in favor of the petitioner, and no proceeding has been initiated against the petitioner while he was in employment for recovery of outstanding dues pursuant to the report of the chief audit officer dated 3/5/2005. Per contra, all the division managers under whom the petition has served during the service period have submitted no due certificate and no objection certificate. Therefore, withholding the retirement benefits admissible to the
what we are indicating to Mr. Counsel for the Corporation. Yes, that's all. That is your submission. And what about the observation regarding the maintainability of the writ petition? What is your submission on that? Because this appeal against such orders has been provided.
Once that part has also been taken care of in this judgment, my lords. That triangular committee appeal has also been taken care of in this judgment, my lords, which I am really.
Just show that part of the judgment.
In this matter, lordship may kindly have. The same para which I was reading, my lords, towards last, my lord. More so the ground that taken that the entitlement of the petitioner such as gratuity and leave salary have been sanctioned and shall be released after final settlement of outstanding dues, that is 5 lakh some odd by the triangular committee in the light of judgment of this honorable court in WPC 16071 of 2006 Raghavananda Das and versus OFDC Limited. The impugned order, my lords, is not tenable, my lords. Whether the triangular committee has taken a decision or not is not ground to withhold the retirement benefit of the petitioner when, as per the service rule applicable to the OFDC Limited, no disciplinary proceeding will be initiated against the petitioner after his retirement, my lord.
Has any disciplinary proceeding been initiated against you?
No, my lords, cannot be. This question has already been settled by the Apex Court in Bhagirathi Janna versus Board of Directors website and others, wherein the Apex Court had held that in absence of any provision, the disciplinary proceeding so initiated stands closed after retirement of the delinquent officer. In paragraph 5 of the said judgment, the Apex Court held as follows: it will be noticed from the above said regulations that no specific provision was made for deducting any amount from the provident fund consequent to any misconduct determined in the departmental inquiry, nor was any provision made for continuing departmental inquiry after superannuation. My lord.
Yes, Mr. Patnaik.
And the petitioner
Only
here,
question
Lord,
that is considering.
was a general manager.
Huh?
Was a general manager. I have given a date chart. I see that date chart for a moment. Even a small date chart.
I have seen it.
So when you are in service, audit reported that yes, you regularize these things. Being general manager, next is managing director. Manager, the head of manager, he is the head of the zone. He very merrily avoided to comply those things. He retired. Then, madam, see that I may place a date chart for a moment.
Yes.
Easier for me to honest. Date chart will submit.
You draw the microphone a little closer to you.
Hello?
Microphone a little closer to you.
Madam,
You're not very.
am I audible?
Yes.
31/10/99, appellant retired from service while holding the post of general manager, Bolangir zone.
Yes.
Then there are no due certificates were called for from the previous stations where the petitioner had worked during service under the corporation. Awaiting such report, the retired dues like petitioner, like unutilized leave salary and gratuity are not released. 14/2/2000, appellant submitted a representation before the chairman OFDC Limited for release of his ULS honorary leave salary on health ground, with undertaking that and any outstanding due can be recovered from his gratuity. On the basis of such undertaking, that undertaking my lord asked for, I have that are filed in the report now with the additional affidavit filed here, it has been annexed. May I place that for a moment? Yes. The language of that letter. That is Annexure D to the additional affidavit filed on 20th March 2023 as a minor direction. In English, my lord, it reads, payment of retirement benefits against encashment of unutilized leave salary. In continuation of my urgent request for medical treatment, managing director has sanctioned the above retirement benefit. I would request you to please disburse the amount on urgent basis before February end to meet the medical expenses. In case of any delayed, OFDC will be responsible for the consequences. I undertake that any outstanding due legally payable by me can be recovered from my gratuity. I would request you to please take immediate steps for early disbursement of the amount in view of the urgency explained. The amount may be disbursed in a back amount. So on this basis, the unutilized leave salary amount was released to him. Then, my lord, I revert back to the date chart, my lord. Then, 3rd August 2000, Board of Directors of OFDC resolved to form a triangular committee to review the position of the pendency, nature of charge, audit report advice, including withheld and disallowed vouchers, and to suggest appropriate course of action with specific emphasis to the death and retired cases. 12/11/2002, office order constituting triangular committee as per the Board of Directors dated 3/8/2000. That's the annexed. 26/12/2002, petitioner filed writ petition 0670706/2002 for payment of the gratuity before the sending the recoveries found against him. Before settling the recoveries found against him. 23/2005, double petition of 6707/2022 was disposed of, directed the OFDC to take the decision on the representation of the petitioner, and if it is security and if it is even scrutiny, it is found that petitioner is entitled to any amount, they may pay the same to him. Then 19/4/95 to this period, the report of the auditors were placed before the triangular committee, which verified the audit reports against the petitioner and decided to drop some of the cases and recover some of the due. Then 26/12/2005, order passed in the chairman of the director corporation for adjusting gratuity of 2,50,000 against the.
So the entire GPF you have adjusted.
Madam. About 6 lakhs, 7 lakhs was found outstanding against him. He did not settle those things.
It is your decision. He have not been allowed to participate in the process of this calculation when you have made that calculation, charging him with
Well,
the liability of more than 7 lakhs and odd.
Audit report, he is supposed to give a reply to them. And when audit report is submitted, he to give a reply. When the audit report is submitted for him, he will give a reply. He did not do that. So therefore, committee was settled up by 3 or 4 officers of the
Can you
corporation.
show that the notice was issued on the basis of the audit reports? Can you show
That part is not clear. That's not.
that part is not there?
No,
actually.
not
that
there.
part is not there.
No, no. Then again, he filed another writ petition after this order. This last, the impugned before this honorable court, single judge at 16071 is filed. And in that order, this honorable court has held like this. But read that that impugned judgment.
Yes.
Consider all the aspects. Then para 5 may be seen. Para 5 onwards. 5 and 6. 2 paras I will place. Para 5 and 6. Perusal of the official dated 22/8/1991 annexes 4 reveals that amount arising out of audit reports which are not being termed as government dues cannot be recovered from DCR gratuity. Such dues can be, however, be realized, provided the responsibility is fixed by the following appropriate procedure. In case of hand, as would be evident from the counter affidavit, the audit report reveals that amount of 7,11,000 is to be recovered from the petitioner. A triangular committee has considered the audit reports and arrived at the conclusion that the said amount can be recovered from the petitioner. It is further averred that against the order of the triangular committee, an appeal lies. The petitioner has not preferred an appeal. That apart the stand taken by the counter affidavit is that the provisions of the civil service pension rule are not in total applicable to the corporation and in consonance with the rule 68, 69, 70 of the American record from the gratuity. Hard counsel for the parties at length peruse the material available on the record. Fact remains an amount of 7,11,000 is sought to be recovered from the petition gratuity in consonance with the audit report, which was confirmed by triangular committee. Law is well settled that in the order of passed by triangular committee, an appeal lies and the petitioner has not preferred an appeal. In aforesaid facts, court cannot issue a writ mandamus direct the corporation for not to adjust the dues from the amount payable to the petitioner for gratuity in view of the letter. Taking stand, the court therefore disposes of the writ petition with devoted to the petitioner final appeal. Well, I have filed a copy of the rule along with date chart filed today. Rule
Did you file
131.
appeal in terms of that order?
What?
Did you file the appeal in terms of that order?
I haven't just come here.
How can you maintain a writ petition then? Because he had not challenged that order of the single judge.
My lords, that is the impugned order in this writ.
There is the impugned order.
My lords.
When you filed it, it is a 2008 order, I think.
2009, my lords.
9.
Not filed appeal.
2008, my lords.
2008 order.
My lords.
1/9/2008. When you filed this writ appeal,
2008, my lords.
it's pending since 2008.
We are given a manual direct, single directed to file an appeal as per the rules. It will be considered by the higher authority.
Which this observation of the learned single judge may not be get any support from at least 3-4 Supreme Court decision where it says, and there is a flagrant violation of the principle of natural justice. The writ court has the power to exercise their jurisdiction under Article
It is up to my lord. It
226.
is a read jurisdiction, my lord.
Then
It is a read jurisdiction. Arbitrarily, he has general
if
manager.
you do not afforded him any opportunity that whether this calculation is right or wrong, whether the liability is acceptable by him or not.
That is up
How
to
can
my
you
lord.
hold that the appellate, he must
I am
cannot
some-
be pushed to the appellate forum.
I don't.
Give the opportunity and decide. We are giving you the opportunity. Give him the opportunity and decide. Disciplinary proceeding is not required. Give the simple way, you just give a notice. This is the audit report. Whatever you want to say within 15 days and you will file. If doesn't file, you decide it.
My lord, that already single judge referred to some rules.
My lord,
68, 69. my lord.
My lords,
Like that.
my lords, third point is, my lord, the rule 123, basing upon which they are recovering on the basis of audit objection, that amendment came into effect in 2004.
No, I am
And
not-
the petitioner retired in 1999.
That
There
is no
cannot be
disciplinary proceeding.
there cannot be retrospective.
No. There is no disciplinary proceeding. The rule, no discipline has been initiated. Authorized and discipline, this is recovery is being made.
We are not on that.
My lord.
Even if you go to the basic principle,
My lord.
against someone, you are just imposing some liability.
My lord.
And liability is relating to that he is liable because of during the performance of his service.
My lord.
He has done something which has caused damage to your institution. You want to recover that.
Proceeding could not have been initiated. My lord.
Ah.
Therefore, because of the lack of provision in the rules at that point of time,
yes,
amendment came 2004. Initiated after retirement, proceeding can initiate. Amendment came to rules 2004. My lord. He retired in 1999.
I'm not talking of
We are not talking of disciplinary.
disciplinary
No,
proceeding.
what was
It is
disciplinary
the
proceeding?
minimum opportunity.
Principles of natural justice. We are
You have
talking
to
about that.
follow whatever there is a rule or not. You are.
I don't dispute that. All single judge has thought it proper. There is a rule for provision appeal. Final appeal reads the question.
We are not pushing him to the appellate authority. Person has already
He has
retired.
come here.
Already
It is
retired.
up to my lord. My duty
Now
to
you
point
can
out what has
also,
happened.
now also you cannot draw up any disciplinary proceeding
No.
against him.
Would not have then also, now also cannot.
Already give him the opportunity because he'll check up the audit reports and
Well,
whatever he says and then decide.
That's all. My lord.
Then if he's agreed, he'll come to court again. What to do?
Well done.
Right?
Right.
No, sir, but the Honorable Supreme Court in Katnaf decision said that recovery cannot be made on basis of audit objection. There has to be a disciplinary
All right.
proceeding.
That's my lord saying.
Disciplinary proceeding should have been initiated to recover, my
Would
lords.
not have been.
So is that your submission?
My lords, should have been initiated to recover. Since it has not been.
Place the judgment. This is
My-
where Supreme Court
my lords,
says.
your lordship,
No, just show today itself.
my lords.
Today itself, you have not prepared with those judgments.
My lords,
It's
99
very
Supreme Court,
unfortunate, Learned Council.
Umagral versus, but I don't have the copy of the judgment, my lords.
This context, perhaps you have not studied properly.
Sorry, my lords, I should
Pardon
have
in
come
court, let the
prepared.
matter be listed tomorrow for
My lord.
continuation of hearing.
Okay.
Mr. S.K. Patnaik, London Senior Counsel is submitted a date chart on behalf of the respondent, which is taken on record. Scan it.
Mr. Patnaik, there was another date chart. This is, you added something, it's the same one.
The new date chart today I have given.
Scan.
I have added that rule 131 and annexed that rule 31 with my lord's date chart also.
You are Mr. Mahapatra?
Vivaswat Mahapatra, I don't have power in this matter, my lords. On behalf of Mr. A.K. Mahapatra, I'm.
That is it.
His father has expired.
Mr. B. Mahapatra, Learned Counsel has appeared on instruction of Mr. A.K. Mahapatra, Learned Counsel for the appellate. He produced your judgments only.
My lords, my lords, my lords.
And before producing the judgment, there will be humble request from this bar. You please study the context of the judgment. Just don't suffer. This you have produced this rule without studying whether it is applicable in the context or not. All right. Keep this judgment also in the record. Yes.
Item 18.
May I please your lordship?
Yes. Okay. Yes.
Madam, the present simple as in file. That case was on 10/10/2006 and one permitted order was passed. Defect pointed out by the SRB removed within a period of 1 week. Failing is the writ petition shall stand dismissed without further reference to the bench. And my lord, on
The writ petition-
12/10/2006.
The writ petition was dismissed by a division bench.
My lord, division bench.
What is the order?
Well, that order was double page number 9582 by 2004.
But you have not annexed that order. The problem is that when you are challenging an order dismissing your writ petition,
My
you
lord.
file an application for the restoration is mandatory provision of rule that you also file a certified copy of that order. Because it has been segregated from the main writ petition. Now it's a fresh petition before us.
You serious about this application? It has been filed since 2010,
Well,
listed in 2018. Now next date is after 5 years, 2023. None appears, none appears. Anyway, the order is not there.
the fact when the order of the Central Administrative Tribunal has been challenged.
No, that is in the writ petition.
That's the writ petition.
The first order was passed on to 10th of October 2006.
16 million.
Directing you to remove the defects.
Million.
And when this order was passed, before that, another order was passed on the 9th of January 2007.
Million.
Observing that no defect was removed by the petitioner, for which the writ petition was dismissed. It is then what remained? What is the cause of action in that writ petition?
2006.
Because we are
Not
in
interested.
almost is 2026. We are very slowly reaching. This is a 20 years difference.
Million.
So what is the subject matter of the writ petition?
The subject matter of the writ petition, my lord, the challenging the
Pension.
order of the Central Administrative Tribunal
Ah.
regarding the getting the pension. They are claiming that for getting the pension because of after 18 years they have filed the for pension or benefit. The tribunal has allowed the same. As because they are working in the 10 years or service, so that was allowed.
They are entitled to, because in view of the rule 54 of the
My lord.
Central CCS Appeal
CCS,
Rules 1972, they are entitled to the pro rata pension.
My lord.
May I submit? No, Lordship. I'm still deprived.
And you are
42
still
years.
sleeping.
As because they are resigned from the
Lordship,
service,
we
they are not.
filed new Wakalatnama in this case, and after
We are
our
not concerned with the filing the Wakalatnama. The writ
Lordship,
petition
after
was
our-
dismissed for non-prosecution.
You're waiting since 2006.
Whether the Central Administrative Tribunal's order has been complied with or not.
it's not complied.
Well, you are sitting. You did not take any contempt action. Do you have the Central Administrative Tribunal's order with you?
Your Lordship.
Give the copy of the order. Do you have today or this is the item number? This one. Okay. All right, return it. We got it. Already got it. It is with the records.
Yes, 38.
This is the 27/8.
Order dated 27/8.
My goodness, 43. Is it typed copy perhaps?
Right? Yes. You haven't given a certified copy of the order.
My lord,
In your writ petition, you have not given a certified copy of the order. In the writ petition, you have not given a certified copy of the order.
my lord, no. Not that is-
You don't have the writ petition with you.
Yes, I have the writ petition with me.
Lordship, the application for restoration was filed after 1114 days delay.
What delay are there? Delay are you speaking about? Think about your delay. The writ petition was filed after delay.
You resigned from the
CM.
service.
My lord, resign is for
We do one thing, we set aside this order, we hear the matter on merit, that you have not also, because I don't think the Central Administrative Tribunal's interpretation of Rule 26 is correct one. Right? So we hear this matter on 21st of July, come prepared. We setting aside this impugned order for these on non-prosecution. Let us hear on the merit and direct them within 30 days if you are entitled to pay the pension.
Not sure.
Right, because it's already now everything is against you because you just slept over the right created by the Central Administrative Tribunal.
Had you already got the pension? Maybe not.
You also take the instruction whether any pension has been released. I don't think because they filed the appeal, they will
Your
not
Lordship,
release
the pension is not
also.
released.
Sorry, not released.
Not released.
He's waiting
Lordship-
patiently till today.
I've taken instruction. Lordship, the petitioner is of 77. He's old.
I was just
and
going to ask,
We
how
can
old is he?
We understand that.
77 years. And the advocate also.
This is an
We have
application.
we have taken the case actually on
Filed by
filed
the
the
opposite
Wakalatnama on
parties.
26th of June last month.
Of the writ petition being WPC number 9582 of 2004. From the Union of India and others. For setting aside the all right. Is this order? The petition I opened it. For setting aside the order dated 9/1/2007 as delivered in the said writ petition. For purpose of the reference, we reproduce the text of the said order below : presented to certified presented the court's order number 2 dated 10/10/2006. Stop. Defects pointed out by the stamp reporter having not been removed. Having not been removed in the stipulated period, i.e. from 10/10/2006 to 17/10/2006, this writ petition stands dismissed. Unquote. Yeah, stop. The said order was passed by the Deputy Registrar Judicial in terms of the order dated 10/10/2006, which reflected that if the steps are not taken, removing the defects, the writ petition shall stands automatically. Steps within which the writ petition shall stands automatically dismissed. Stop. You are appearing for the first time?
My lord.
Mr. Bhutta,
No, my lord, I am J.
Mr.
Naik.
Naik, J. Naik, Mr. J. Naik,
CGC, Central Government Council.
CGC has appeared for the petition.
Delay in filing the CMPL.
Here's the certified copy of the, no, it is not there. As the certified copy of the impugned order has not been filed by the applicant, no service report has been made. Or his stamp report has not been made. Having considered the nature of non-prosecution, we condone the delay, if any, that is occurred. We are just recording that you have no objection because we are going into the merit of the matter.
Lordship.
Otherwise, we have to pass the order differently. Now you decide, otherwise we can accommodate you. Mr. This Naik, you just see this, there is no certified copy, no.
That is 3 years delay. Why don't we pay him some cost?
The proposal is the 10,000 cost should be imposed on you.
Union government, we may not ultimately get any pension. Let him get something. But this will
What is your good name?
Samarendra Beura.
Huh?
Samarendra Beura, your lord.
You have filed this Samarendra
Beura.
Beura, and it counsel has appeared for the original applicant who filed the original application being OA number 678/1999. Stop. Has not opposed the prayer on condition that the cost shall be imposed on the central government for all the delayed filing. Stop. We condone the delay as occurred in filing this application for setting aside the order for non-prosecution as stated above, subject to payment of rupees 5,000 within a period of 7 days from today to Mr. Beurel and counsel appearing for the
15 day.
7 days.
15 day.
15 days within to Mr. Beura for 15 days. To Mr. through should be made to Mr. Beura by what means? By a check.
I may be read the letter to the department thereafter. That's why I'm saying
By check.
By check, we can pay that check.
By demand draft / or banker's checks in the name of the respondent. Stop. Let the matter be listed on 10th of August 2023 for consideration of the CMAPL 53 of 2010 on merit. Stop. Mr. Beurel and the counsel is requested by this court to take instructions from the original applicant whether the Union of India has made any communication regarding release of his pension. Already any communication that we filed in appeal or not? Stop by the next date. We fixed it on 10th of August.
My lord.
So we pay within 15 days. Otherwise, without looking at that, you will dismiss this application.
My lord.
And you just study Rule 26 of the CCA pension rules of 1972 very carefully.
Item 19.
My lord, item 19, on behalf of Mr. Siddheswar Mahanti may be taken up 2 weeks.
Tomorrow.
Time may be. We see the underwent a surgery. At the meantime, we'll take instruction on affidavit filed by the IS.
Your Lordship may kindly indicate that pursuant to the last order, we have filed an affidavit.
Okay, let us see. So the
That is the
examination
status
of the witnesses has been carried out by a person who doesn't have the jurisdiction over the offense.
Yes. Last order was a direction was given to us to file the status of that particular case.
That is there. And now we are looking into this. There is a GR case of 2012. Now, after almost 10 years, it is discovered
For commitment.
that the court doesn't have the jurisdiction.
Lordship may direct the trial court to expedite. That can be.
But in Orissa, the 7 years case is only exclusively triable by the Sessions Court.
That is there. That is why it was committed
No,
to this.
not how, but the Chief Judicial Magistrate should have the tribal jurisdiction. Mr. Muduli, do you have any idea about these things? It's Chief Judicial Magistrate cannot try the offense punishable for the 7 years.
The offense under section?
No, I don't think especially. They are
My
also
lord is not
all grade
audible.
2 officers, huh? These are all grade 2 officers. They should have this power. Let us examine this matter. I don't think this is a correct position has been taken by the court. Nobody is there who are the carrying out a trial in the district courts. All right, what is your prayer to take adjournment?
No, 2 weeks time maybe. On behalf of the Siddheswar Mahanti, my lord.
How much time?
2 weeks time.
2 weeks time. Is it too long a time? 3rd of August, is it find out a date is possible?
Yes.
Let the matter be listed on 3rd of August, 2023. At the request of your Mr.
Sandeep Patnaik, S. Patnaik.
Mr. S. Patnaik and counsel appearing for the petitioner. Mr. D.K. Mohanty, learned counsel, has appeared for the state respondents. Mr. Mohanty has produced the affidavit filed by the inspector in charge, Lathur Police Station, in terms of our order dated 13/4/2023. Said affidavit is taken by the court.
Item 20.
The public interest litigation.
Yes.
The first dispose of that your lordship will find that order.
Mr. Mohanty, just take the microphone a little closer to you.
Your Lordship will find the writ petition was first instance was disposed of by order dated 30/10/2014.
Okay.
This was the matter. Let me just apprise your Lordships. This 33 persons, they
Yes.
encroached the government land. And that is about 4 acres of government land. Then under the OPLE Act, they are all directed to be evicted. And that was finalized also. They have not challenged anything. So that is why the villagers and Panchayat people at their instance.
What is that order?
the
It is,
Administration was persuaded to evict them. So then this writ petition was filed. Ultimately, state was to file the counter, virtually admitting the position. And then direction was given to evict them. So this 33.
What is that order? By which the direction was given?
That was given in 30/10/2014.
30/10.
Yes.
In this writ petition?
In this writ petition.
Annex question. Annex
question. Writ petition order. Annex question. You order sheet receiver, na?
Because the last order in this writ petition is.
Yes, I am coming to that.
12 January 2023.
Yes.
You are referring to 13/10/2014.
14. In fact, that order was passed. But this out of those 33 persons, 19%, they went against that to the apex court. The apex court dismissed that. Then they filed a review petition. They are not parties. So that is why, however, the review was allowed. And consequently, this is the order dated 12/1/2023. The last order. In the review, that order
So
was
they have been, now they are the opposite parties.
They are the opposite parties. They are all.
Who is the council representing
Mr.
them?
Ratho was appearing. I don't.
Mr. Ratho was appearing. That case.
That. And they have not filed also any.
Srikara Ratho, I am sorry.
Srikara.
I think.
What I appraise your Lordship, if they don't file any counter, nothing, ultimately that order is to be passed, which was passed.
No. If the council is not appearing and they have gone as far as the Supreme Court, should we not give them a notice?
They have appeared. In the review petition, they were made party.
Personally appeared.
Yes.
Personally appeared.
Mr. Roth appeared.
Exactly. That is what I am saying. If the council does not appear, should we not give them one chance?
That your Lordship may
That
give.
is what I am
This
saying.
is my duty.
No, just the
that this is the
Mr.
position.
Mohanty, you just come to the para 4 of the 12th January order. It has given some directions on you will be authorities will be asked to undertake an inquiry into the present
my
status
lord,
of
that
each of the newly added opposite parties and submit a report.
Last order.
The said report be placed before this court along with an affidavit within a period of 12 weeks from today. Did you file such affidavit?
My lord, that affidavit we have not received, but
They have filed the counter affidavit. Any further development?
That is why after the addition of those persons, court has directed to inquire into the matter. What is the present status of those persons?
Yes.
So we fixed this matter in 16th of August. Again, you just comply the direction of this code available in para 4 of the said order, right?
Yes.
Mr. D.K. Mohanty, an additional government advocate appearing for the opposite parties, state opposite parties, has submitted that in terms of the order dated 12 January 2023, the state could not file the present status of each of the newly added opposite parties, i.e. opposite parties number 8 to 27, and submit a report. Stop. Having considered the relevance of such a report, let the matter be listed on 16/8/2023. Meanwhile, the state opposite parties has complied the order dated 12/1/2023 by filing a report as asked for. Mr. P.K. Mohanty, on his senior counsel, has appeared for the petitioners. It is made absolutely clear that such affidavit shall invariably filed by the next state Stop. None appears for the opposite parties number 8 to 27 when the matter is taken up today. So if there is no representation on the next date, this court will be persuaded to hear the matter in their absence.
Nor also they have filed any counter pursuant to that.
All right, they stop. Those opposite parties are given liberty to file the counter affidavit or any other form of affidavit if they are so advised. All right, next.
16th August.
23.
Interim order is there?
16th August.
16th August. There is, I think there is no interim order in this case.
No,
All right.
no, there's some status quo order. I think. Which the opposite parties have been stated not to violate.
Okay. Item 21.
23. 23. Lord 23 might be this a lot, sir. Lordship, this is a public interest litigation. The petitioner has challenged the virus of section 166 clause 3 of the Motor Vehicle Act, which has been
Urgent to 10th of August.
10th of August. Okay, record it. What are you doing? Yes, call the next matter.
25.
25, my lord, this is a matter relating to the death of the sanitation workers, wherein this court is monitoring the Prohibition of Employment and Manual Scavengers Act's implementation.
Yes.
As per the last order, my
Kindly see
Lord
the
and
last
friend,
order dated 3/5/2023.
my lord and friend has today filed a affidavit on behalf of opposite party number 1 and 2. And they have sought me the copy right now, my lord. That may grant me some time to go through this and to file my reply.
31st July is all right?
Yes, madam. Deeply blessed.
I appear on behalf of Ms. Pamirath, Lord.
Huh?
I appear on behalf of Ms. Pamirath.
All
Am I
right.
correct?
I have sought the copies of the affidavit.
We are two amicus curiae who are being appointed. Ms. Pamirath was appointed and myself, Vibhu Prasad Tripathi, is appointed as amicus curiae in this matter.
So amicus curiae, he is appearing on her behalf.
Yes, because he is.
The request of Mr. BP Tripathi, amicus curiae, that the matter be listed on 31st of July 2023. It is expected that the petitioner shall file their responses in respect of the affidavit filed the opposite parties number 1 to 3 in compliance to the order dated 3/5/2023 by the next date. The amicus curiae, not the petitioner, amicus curiae should you file. This counter affidavit filing the proceeding is taken on record.
26.
26, my lord, I'm appearing for the petitioners, my lord. I pray for after recess, my lord. Learned seniors, yes, my lord. Obliged.
Will be taken, keep note after recess. Yes, next.
28.
Item 28, I pray for after recess, after launch, my lord. On behalf of Mr. Subhasis for petitioner in WA 81 of 2022, I pray after launch.
29.
My lordship has already issued notice. My lord, I am appearing, my lord, in this case.
You are appearing for the respondents? You are appearing for the respondents?
Yes, my lord, for the respondent, my lord.
Filed
Both the
your,
companies, my
filed
lord.
your power?
My lord, I have already filed my.
Today?
No, my lord, on Friday. Friday we have filed.
No delay, no delay. Like you appeared in both the matters
Yes, my lord.
and sole opposite party.
Yes, ma'am.
Is item number 20.
9.
Question is,
The Mr. Patnaik, what is his first name? Mr. Abhijit Patnaik. And councillors, you are appearing for all the respondents, I
right,
think.
there is only one
Oh, one
respondent.
respondent.
One respondent.
Has appeared for the,
No, there are 2 pro forma respondents.
all of the Mahanadi coalfields.
Yes, yes,
Limited
I'm the appellant.
And has appeared for the respondent number 1. And Mr. Who is appearing for the central government in this matter?
So it is a pro forma. my lord. Pro forma is not
All right.
needed exactly.
There is no representation from the pro forma respondent. You are Mr. Sahu.
Yes, madam.
Mr. N.C. Sahu, London Council appears for the appellants. So, this is the first IA is for the condonation of delay.
Delay, my lordship, there is no delay. Yes, sir, is that.
Yes, in view of the.
On
in IA
precaution, we
number
have had.
36, just wait. 1232 of 2020, in view of the stamp report, this application has turned inessential and accordingly the same stands disposed of. Another is a stay of order.
Yes,
always.
yes.
Wait.
Who's that?
So what is your, this, why have you challenged? What is the basic
My
ground of
lordship,
challenging
we
the?
have challenged on the 2 grounds, my lordship.
Ah,
My lordship, annexer 1, that is the order of single, that is on being put here, my lordship.
yes.
2 grounds. One is the maintainability of the petition and the matter, in the sense that CMD, they have, in the request, they have made CMD, Manit culture is by opposite party. Our contention is that it has to be, that is wrong. The REIT is maintainable against Mahanadi coalfields. That's what 2 decisions also, I have got 2 decisions. Because relief is sought for against Mahanadi coalfields.
Yes.
And article on Article 212 also, the MCL should have been the party.
MCL is the party.
Another on merits, they have relied on a report dated 25/5/2006. That is only a recommended in nature. That has not even accepted by the Mahanadi coalfields. On 2 grounds I have taken.
My lord, the basics.
So virtually you were not heard at all. You are not heard because you are not party in that proceeding, writ petition. In the writ petition, you are not, Mahanadi was not a party.
CMD is a party.
But appellants were not party.
Chairman Managing Director.
They were heard, my.
Now, if the CMD is a party, what is your ground? The technical objection, why the Mahanadi was not made party? 1983 Supreme Court says if the chief principal officers are made party, it is a mere technical omission.
Because
we understand they are necessary party because whatever the direction, ultimately it is to the Mahanadi coalfields will comply it,
yes,
not the officer. You're absolutely right, but when a responsible officer, like
yes,
the chairman
there,
or managing director is made part.
There is 2 decisions, my lordship, kindly.
Yes.
In a one is 1977 Supreme
Mr.
Court.
Patnaik, are you ready?
Yes, my
My
lord.
lord, I am ready to this. What I am submitting is this, my lord. This is a very old matter, my lord. It is with regard to the lead distance, whether it will be 6 to 7 or 5 to 6.
Exactly.
Technical committee has recommended it to be 6 to 7 after a lot of representation, my lord. It's a very old matter. My money is pending with them. They are not releasing my money now.
Take the judgments. We'll take up the matter tomorrow. Please take note of the judgments.
My lord, I'll take.
Let the matter be listed tomorrow for admission.
Tomorrow, my lord, day after tomorrow.
Day after tomorrow?
Yes, yes.
Day after tomorrow for admission.
My lord, only.
And this court proposes that at that stage, the matter will be taken up for disposal. You come prepared with the, Mr. Saul and its counsel, appearing to the appellant, has produced two judgment of the apex court, being General Manager, Ranjit Mall versus General Manager, Northern Railway, Baroda House, New Delhi, colon 1977 1 SCC 484, and Champalal versus State of Punjab and others, 2014 1 15 SCC 517, in support of the grounds as taken in the appeal. So already tomorrow.
The only thing that they have appeared for MCL. Man, only thing that we have to keep in mind, my lord, they have appeared for the MCL. Not that.
Only will consider, only thing you'll consider on merit.
Merit also we have a case.
Yes.
Item 30.
Same night, same.
Same order.
31.
May I please, your lordship?
Yes.
This appeal is filed against the order passed by the single judge, thereby directing to give promotion to the petitioner during after opening of the sealed cover procedure. But fact of the case is that during pendency of a disciplinary proceeding and criminal vigilance case against the petitioner, or his case has been
considered and put under sealed cover.
Yes,
and then
but that was pending. At that point of time, the petitioner approached the Honorable Learned Tribunal, which has been transferred before this Honorable Court, and the Learned Single Judge had order dated 8/10/2021 disposed of the writ petition. Honorable Lordship, kindly see Annexure 1, the order. Not paragraph 5. The very
Paragraph
fact,
5?
my lord, fact involving the case reveals that there is no disciplinary proceeding against the petitioner except the vigilance proceeding pending in the court of Special Judge Vigilance Bhubaneswar in vigilance case number. But then, my lord, reading in the last two lines, reading also further made clear that no disciplinary proceeding initiated against the petitioner. But that is not correct. But here a disciplinary proceeding has been initiated against the petitioner since 2016. Lordship, kindly see Annexure 4, the recommendation of the DPC held on 17/1/2017 at page 20.
Did you submit these records before the Learned Single Judge, Annexure 4?
No, on the very first day, but that record has not been submitted.
How have you introduced this record this way by an annexure with the writ appeal?
But
what is the opportunity of the writ petitioner to contest this correctness of that document?
But after transfer of writ petition, on the same day, the writ application has been disposed.
You file an application seeking leave of the court to introduce this document following the principle of Order 41, Rule 27. Otherwise, it's very difficult. They should have a right. At this point, you can file. We are not saying that you cannot file, but they must get an opportunity to contest. You give the reasons that no opportunity was provided after coming, because you are supposed to file before the tribunal, not in the High Court. So we are just adjourning the matter. Take up on 31st of July again, at the request of Mr. J. Naik, Learned Counsel, appearing for the appellants. Let the matter be listed on 31st July 2023. We find from the records a few documents has been introduced at the writ appellate stage without taking leave of this court. Mr. Naik,
Mr. Behra.
Mr. Behra and counsel has stated that when the matter was transferred to the High Court, they did not get any opportunity to make approach to the High Court for acceptance of this document, as on the very first date, the writ petition was disposed of by the impugned order dated 8/10/2021. Be that as it may, we are of the prima facie view that the writ petitioner, sorry, the applicant, now the writ petitioner should have an opportunity to contest the perspective fact in which the documents were considered relevant in the case. Let the matter be listed on 31st July 2023. You are appearing for the writ petition.
Respondent, my lord.
Mr. R.K. Bishoy, Learned
Yes.
Counsel, appears for the respondent.
Yeah. Sufficient opportunity was given to them. The OA was filed before the Law and Tribunal in 2000.
You just, they let them file.
Did that in your objection, like?
Yes.
They let them file. That is why you are telling. They say that we have not given opportunity. Let them say it, why they have not filed.
32.
Interim order to continue. Lord, there is interim.
Interim order is there. Interim
Yes.
order is passed earlier, shall continue. Yes, Mr. Kuntia.
May I please? This is notice has been issued, none has appeared. Lordship can impugned order is at page 23.
It appears from the registry's note dated 5/7/2023. That the notice issued by the registered post on admission of the appeal and stay of the impugned order has returned after valid service, but there is no representation. Then the matter be listed again on 16/8/2023. Stop. There is any interim order of stay?
Yes, madam.
The interim order is passed earlier, shall continue till the next date. All right. 16th August.
33.
I beg pardon, my lord. I beg pardon. I was held up in court number 6, my lord. In item 30, I am appearing for OP number 203, my lord.
You are appearing for whom? Appellants?
No, my lord. Opposite bed number 203. Director General, Resettlement, Government of India, Minister of Defence, and Union of India, Minister of Coal. Item 32.
All right.
I have filed my appearance memo. I have filed my appearance memo.
Affidavit.
Appearance memo.
All right. The request of Mr. B.S. Rai Guru, Learned Counsel, appearing for the respondents number 2 and 3. Let the matter be listed on 1st of August.
So that is open, man.
The order has been passed, the matter has been adjourned.
When? 16/8.
It is 19/7.
So it will come in on 19th, sir.
Yes,
You
ma'am.
take this, huh? Just.
Obliged.
All right.
33.
33, my lord, I'm for the appellant and challenging the order dated 8/9/2022 passed by the Honorable Single Judge. And the issue that is debated before the Honorable Single Judge is whether a co-owner can sell a specific portion of land in an undivided estate.
Yes.
And the Honorable Single Judge has held that's the same violates Section 44 of the Transfer of Property Act.
Section?
Section 44 of the Transfer of Property Act.
Violation?
Yes, madam. That's what the Honorable Single Judge has held. That selling up specific portion of.
Section 44 provides certain contingencies when the right revives.
Absolutely, my lord. Absolutely, my lord. And that is covered by the Honorable Apex Court judgment. This is no more res integra. And the Punjab Haryana full bench decision.
It's all right. No decision is required to understand section
My lord.
44. Mr. Mohanty?
My lord, what has happened in this case? there are four, let us say four co-owners. And one of the co-owners, and admittedly there is no partition by meets and bounds between all the co-owners. And one of the co-owner is trying to execute the sell deed in respect of his undivided portion to an outsider, not amongst the co-sharer. Had it been amongst the co-sharers, then matter would have been different. So to an outsider, he is trying to sell out his so-called 1/4 share, or for the as example I am giving.
Issue is very simple, Mr. Mohanty, whether the share can be transferred,
Undivided
whether
share
there is
can be
any
transferred.
preemptory right of the other co-sharers. And if done without following this right, what will be the consequence? Consequence is that when that lead share will come to this co-sharer who is entitled to get the benefit of
The
it.
Honorable Single Judge has viewed that there is no identity of the land which is sought to be transferred from the vendor to vendee, because
No, there cannot be. That is why section 43 and 44 is there in the
no,
statute.
44 is if your lordship will place 44.
Yes.
44 says that where one or more two co-owners of immovable property legally.
Are you ready for the hearing today?
No, any day, any other date, your lordship.
We are admitting this appeal and fixing the matter to be heard on 1st of August.
And all judgments I have given already.
No, that is there.
Oh,
I have not
cited
checked
on-
up.
The direction was to
Ah,
provide a
already
copy of land.
No, sir, everything.
ଆପଣ ଏଇଟା ନେଇଯାଆନ୍ତୁ ତ ମୁଁ ପୁରା
Yes,
You
sir.
put a
There is
judgment zone.
1 or 2 days delay is there. Have you filed any application?
That has been condoned, I think, at the time.
Have you filed?
That is fast order, your lordship can.
It has been condoned already.
Yes, madam.
Which is the date of the order you are referring to, the first order?
My lord, 8th of September 2022.
8th of September 22.
Is the impugned order that?
No, I'm talking about there is a delay. You have not filed any, apparently it appears to us that you have not filed any application. You come to the service report.
This appeal was filed on 8th/10. Order I received.
2 days delay, they are showing it.
Lordship,
Because no, so just you take note of this. The judgment was passed on 8/9/2022.
Yes, ma'am.
Am I correct?
Yes, madam.
And that, so within a limitation, you are supposed to file on 11/9/2022.
Yes, madam.
Total period taken in the process is 33 days. So the uncertified copy procuring say 1 day was consumed. So the 31 or 30 plus 31 and 33 minus 31 is 2 days delay.
I pray your lordship, I condone only government is the party.
Mr. Rath,
Without application, 1 page of application, you should file.
I'll file.
you're saying it is condoned. It has not been condoned. The court has observed that you have stated that there is no delay.
That is what.
Actually,
And that is why the case has been posted for the arguments.
Had it been condoned, that's different. Yet to be condoned.
All right.
2 days delay, so just.
I will file, my lord, that's not.
At the request of Mr. G.M. Roth, learned counsel appearing for the appellant, let the matter be listed on 31st of July.
Yes, ma'am.
31st of July 2023. Meanwhile, necessary steps in respect to the limitation be taken by the appellants. So Mr. D.K. Mohanty, learned additional government advocate appears. All the state respondents,
All the states respond.
appears for the state respondents. All. Call another matter.
34. Published.
My lord, 34, 35.
Hmm.
The prayer of the petitioner in the writ petition, my lord, that they shall not be evicted without following the due process of law, my lord. They have initiated an enforcement proceeding against a person who is not in possession of the property.
No, because I do not know exactly what is the state eviction law. Because the central eviction law, most of the state has replicated that law. And there is a section 6 of the eviction says there is a distinction between the section 5 proceeding and section 6 proceeding.
Here, my lord, section 7 of the OPL Act.
I think it is equivalent to section 6 of the Central Act.
Yes, my lord.
The structures they remove.
My lord.
For that, no notice is required.
Yes. No, my lord. Section 7 of the OPLA Act
Ah.
prescribes that after serving a notice, after initiating a proceeding, and after serving a notice,
Where is the copy
and
of the
after
notice?
again
Where is the copy of the notice?
notice, my lord, that is under annexure. That was my lord, that was initiated annexure 5, page 18, my lord.
Yes, Mr. Mohanty, do you
Only fair,
think
my
this is a
lord, they
proper
shall
procedure on statutory provision prescribed that you should issue notice and you have not issued notice?
no, not read. My lord, proceeding has also not initiated against me, my lord,
Why have you come to the court then?
because I am in possession of that land, my lord.
But if there is no threatening, if nobody
Uh-huh.
has issued eviction notice to you.
My lord, yes, against a strange person, they will, my lord, initiate the proceeding. That will, my lord, ended in by an order of eviction. Then, my lord, they will come and evict me. I have come to the court that I am in possession of the land, government land. Admittedly, it is a government land. I am not disputing that. But they should have initiated a proceeding against me.
You want that a proceeding should be initiated against
Yes,
you?
yes.
The view, your lordship may see the view of the honorable single judge in the impugned order at page 28.
No, whether you are in the actual position or not.
I am in actual possession. I have given the documents, my lord. That
No,
electricity connection,
Documents? No,
water
document.
connection, everything has been given to that plot.
So what is this order, the London single judge's order? Where is that order?
Page
That is-
27 and 28. 28 is important.
27, my lord. Here, your lordship, paragraph 3, petitioner has filed this statement seeking direction to appeal not to evict him from the land in question without following the due process of law. Thereafter, my lord, have proceeded
Para 6, having heard learned counsel for
parties and record this court opinion that if the proceeding has been initiated against a person who is not in accused person's land, in that case, the petitioner is a right to approach the appropriate forum. Where, my lord, I will go to right appropriate forum ventilating the grievance.
Just give this act, this section 7.
This is the only forum, my lord.
No, there is an issue in it only for obviously. We are marking it part heard. We will continue tomorrow.
this tomorrow.
All right, both the matters heard in part. List the matter for continuation of hearing tomorrow. Give the date only, not tomorrow. Huh? In both the matters, you are appearing for these appellants.
Yes, both the matters
Ms.
is there.
D. Mahapatra, counsel appears for the appellant, and Mr. D. K. Mohanty, counsel appears for the state respondents. Only the state respondents are there. All the municipal corporation is there.
No, land belongs to the government, my lord, not municipal corporation. I have implemented municipal corporation as one of the party.
You have implemented municipal. No, I don't think so. No, all the government responded. So, all right. Tomorrow, next also same order. So other matters will be taken up to the recess.
My lord, one thing, my lord, I have come to before your lordship that the petitioner shall not be evicted without following the due process of law. But I have been evicted without following the due process of law, my lord. Where I was sitting for last 37 years, my lord. I have been evicted.
Encroachment of government land, even if for but it's not audible, my lord.
When the procedure is laid down, how
Yes,
you can defy the procedure? That is the issue.
If your lordship will go through the impugned order, the honorable court has said that if there is no proceeding against you, then there is no cause of action for you to come to court. You can ventilate your grievance before the appropriate. Tahsildar is the appropriate authority where the proceeding is ought to be initiated.
Something very abstract in law. You have already evicted them. We'll decide next day.
Yes, ma'am.
All the issues as it comes. Mr. Do you have any matter?
After lunch,
All right.
Item 2. At 21.
That is it.
So if I may please your lordships, my lord. My lord, a writ appeal challenging the order of the learned single judge, wherein, my lord, the learned single judge has declined to interfere with the orders passed by the collector regarding the appointment of the appellant petitioner.
Yes.
My lords, may I kindly have the writ petition?
Yes.
Yes. My lord, the advertisement is there at annexure 2, page 13 to 15. For your lordship's convenience, I've just made a English translation of the relevant parts. My lord. Oh, yeah, your lordship would kindly see page 13. My lord, I've translated a copy for your lordship's convenience. My lord, this is the advertisement wherein there are specific term and condition at serial number 1 has been mentioned that interested women candidates, volunteer candidates must be a resident of the boundaries of the resident of the center area. Your lordships have got that?
Yes.
So, my lord, the entire dispute revolves around this one particular clause, whether the petitioner, the contesting opposite party, were residents of the boundaries of the center area or not. Your lordship may for a moment kindly have the next page of the translated copy, my lord. My lord, of the advertisement, serial number 17 is relevant. My lord, which says that for Hilunga 3, the present case which concerns the area, my lord, the area that is to be demarcated is from the school sahi of Ramakrishna Mahakud to Jogendra Mirdha. Your lordship would just mark that. That is the area demarcated at serial number 17.
Yes.
So, my lord, the persons who are eligible to be applying for Hilunga 3 area must be residents between the school sahi Ramakrishna Mahakud's place to Jogendra Mirdha's place. Accordingly, your lordship, I have all that was been done at page 15. Your lordship would see I've given of the translated copy. Point number 5, that proposal of determination has been given confirmation.
Yes.
Thereafter, my lord, at page 18.
This is the Angarwadi center where you had applied.
Indeed, your lordship. Helung 3 is the concern, is the area to which I have applied. And thereafter, your lordship, the demarcation area is mentioned as I've shown your lordship at page 14, which would be from the school side of Ramakrishna Mahakud to Jogendra Mirda. And as per the terms and conditions, he should be a resident of that particular area. So thereafter, your lordships may kindly have page 18. This is the demarcated area. Your lordship may kindly have the brief and then the translated copy. It would be easier to read, my lord. My lord would just mark, my lord, although it is in ODIA 422, your lordship may just see for a moment. The top middle serial number 422 at page 18.
The annexure 2 of the writ petition.
Annexure 4 of the writ petition now, your lordship. Indeed, your lordship. Indeed, your ladyship.
List.
Annexure 4, page 18 of the writ petition, my lord.
Yes.
Yes. Your lordship, although it's an ODIA, my lord, 422. Your lordship would just see the serial number 422, the second, the middle first, the top line center.
Yes.
My lord, I've given the translated copy, my lord. My lord, this is the place from which it begins, which is Jogendra Mirda. I've given the translated copy. Your lordship would kindly see. 422 is the house of Jogendra Mirda. And from there, it lordships would just come to the page number 20. Page number 20 at serial number 500.
Serial number?
Page 18,
500.
serial number 422, and thereafter page 20, serial number 500.
Yes.
That is Ramakrishna Mahakud.
Yes.
So all of these are the persons who are the residents of Hilung area as per the advertisement is my contention. And your lordship would find my name at 495. Lakshman Bhoi is my father.
Okay.
Lakshman Bhai is my father, and I'm a resident of these areas within, as per the guidelines, from 422 to 500, and I am at serial number 495.
So how do you get it is of this area?
My lord, that is of Hilung 3, my lord. My lord, the survey that was conducted,
For
your lordship would see at the top,
what's the heading?
block Hilung,
Hilung block
Bir Maharajpur, Jilla Subarnapur, for this.
Why do you say it's Hilung 3?
My lord, this is what is the calculation, my lord, because of this, your lordships, they had subsequently undertaken the entire surveys, and I was given appointment being the highest grade, being the highest secured of rank. Your lordship would just see that at annexure 5, page 21.
So there is no dispute that you are a resident of the area.
No, my lord. A dispute has cropped up, and thereafter, my lord, a survey has been done by virtue of which, my lord, they say in 2014, although I fall under the categories, my lord.
You are referring for the selection list at page 21.
Page 21 is the selection, my lord.
What is his name?
The second name, Pramila Bhoi. Your lordship would see the mark, my lord, 58.33, the highest secured rank.
Yes. Whether this state has filed any reply?
I'm sorry, your lordship.
Whether state has filed any counter affidavit?
No, madam.
My lord, state has not filed any counter.
In the writ.
No, who is opposite party number 1?
Yes, well, that order was challenged. You also can see the appellate authority's order, which was challenged in the writ petition, madam, you can see.
Page.
It starts from page 9 of the writ petition.
Writ petition.
The relevant portion, my lord, you kindly see
10.
from page 10 bottom. Subparagraph. May I place, my lord?
Yes.
On verification of certificate and mark sheet, it can be seen that the appellant is academically more meritorious. Appellant means that the present respondent number 4 is more academically more meritorious than the respondent number 1, who secured 350 marks out of 750 in high school certificate examination and 400 marks out of 600 marks in annual higher secondary examination certificate arts, and placed in second division and first division respectively. It is well worth of special mention that the appellant had experience of working as ASA healing under CHC Bir Maharajpur since 1/8/2007 till 30/3/2012,
which was communicated by letter number so and so dated 33/2012 of medical officer in charge CHC Biramaharajpur and also by the CDPO Biramaharajpur.
Inquiry there.
This is the relevant first. Hard learned counsel for the parties and report of CDPO Biramaharajpur communicated by letter number 690 dated 22/10/2014 in response to district office letter number so dated 21/8/2014. The CDPO has clearly reported that Srimati Bhumi Sutta Mohar, wife of so and so, is coming under Hilung 3 Anganwadi Center with name and serial number 10. Well, this Bhumi Sutta Mohar is the present respondent number 4. The report copy is enclosed in this case record. Also perused all the relevant documents and materials. The selection of respondent number 1, that is present appellant, as Anganwadi worker of Hilung Center 3 Anganwadi Center is illegal and arbitrary, as the respondent number 1 does not belong to the service area of Anganwadi Center 3 of Hilung village, which is a prerequisite for selection of Anganwadi worker. The applicant must be resident of the service area is one of the essential qualifications which is required to be fulfilled as a statutory requirement. It is clearly evident from the report that the Anganwadi center area of Hilung 3 has been well defined and the respondent number 1 does not belong to the Anganwadi center area. Her application should have been rejected at the preliminary stage. The CDPO and other members of the selection committee have committed deliberate lapses and gross irregularity by selecting the respondent number 1 as Anganwadi worker Hilung 3 center. It is needless to say that the selection of respondent number 1 as Anganwadi worker is bad. Hence, the engagement order of the selection committee selecting respondent is quashed. The selection committee directed to engage the appellant as so upon inquiry, they found that the present appellant is not residing within the center area of Hilung Anganwadi Center 3. That's why his selection has been set aside. But that's a factual finding.
The evidence of the electoral roll,
yes,
it shows that she used to reside in.
Your Lordship may kindly see those two documents. Advertisement was issued in the year 2012.
Yes.
Subsequently, it has been it was issued in 2014. Voter list is of the year 2014, and selection was made in the year 2012.
But the voter list usually they maintain this same thing actually, and she is not a very new voter.
My lord is not audible.
No, I think the petitioner is not a new voter, considering her age.
What about the earlier voter list? That was prepared when?
He should produce that.
You don't have any other document in support?
My lord, the basis on which I was rejected, Your Lordship may kindly see annexure 10, page 31, the survey report that they're talking about.
Page?
Page 31, it starts. The document referred to, with reference to the subject cited above, I am submit herewith the factual report on demarcation of service Srimati Bhumi Sutta Mahar is coming under Hilung Anganwadi Center 3 at serial number 10, and Mari Pramila Bhoi, daughter of Lakshman Bhoi, is coming under Hilung Anganwadi Center 2 at serial 68. The survey report of Hilung 2 and 3 is enclosed herewith for reference. My lord, may kindly see the next page. I've given a translated copy. Hilung 3, that's there at page 32 and 33. Yes. I've given a translated copy, my lord. Hilung 3, my lord, has already seen that it was supposed to be from the house of Jogendra Mirda to Rajkrishna Mahakur to Jogendra Mirda. Your lordship will just see serial number 1, 2, 3, and 4. These are the 4 houses, which is as per the survey report, that this is the center for these 4 houses. Assuming, my lord, for the sake of argument, but not considering to the same, my lord, even the respondent number 5 does not in any manner, the name does not find place within the serial numbers of 1 to 4. What they say is that serial number 10 is the house of the respondent number 5. So the respondent number 5 in herself, by challenging and getting an appointment, by challenging my appointment, would not stand on the first leg itself. The survey report does not support their case also. In case that is the case, your lordship, the survey report of these 4 houses, my lord, cannot be the center for an entire Anganwadi center. 4 houses cannot consist of Anganwadi center, your lordship. So therefore, my lord, the voters list, my lord, that was there on the very next elections of 2014. The demarcation done was from 422 to 500 is my respectful submission, Your Lordship. Instead of that, my lord, the learned appellate authority has allowed the prayer of the respondent number 5 and cancelled my engagement, which Your Lordship would see at page 25. My engagement letter issued for the very self-same purpose, and thereafter the appeal was preferred by respondent number 5, on which she won, to which I had preferred a writ petition, which was dismissed. And accordingly, I am before Your Lordships on a writ appeal.
So she had come up in by filing a writ petition. This court sent her to file appeal.
Your Lordship.
Appeal was allowed in her favor.
Your Lordship.
You've challenged the order in writ, which was dismissed. And what are the reasons of the learned single judge?
My lord, the learned single judge's order, Your Lordship would see.
Page.
Order number 6. It appears there is no, and my lords have got it?
No. Just a minute. There are no annexures to the writ appeal.
My lord, writ appeal, my lord, I have annexed.
There's the order, got it. 2015 order, okay.
Mr. Tripathi is appearing for the writ, this candidate who got selected.
My lord.
There is another person, they just come. Has been, our name has been stated in the ground.
Who's OP4? You?
My lord, I am for
OP4?
My lord.
Are you for OP4?
My lord.
That means you also can't be appointed.
No, my lord, that is
This
That is the order of the single judge.
This finding is contrary to the appellate authority, sir.
Since I
So.
No, that was its
Fine, but
contention.
this is the order of this court.
No, in fact, that was the contention of the appellant before the appellate authority at page 10. That
My
has been
lord.
taken note of as finding.
This is the order.
The report relied by my learned friend, my
So
lord.
you fight for the pitha and then nobody gets.
By another CDPO and my lord, the report relied by
This
the
electoral roll was part of your writ petition.
Yes, Your Lordship.
And what is the stand of the state about this?
My lord, state has not filed any counter in the writ petition.
Mr. Mudali, how can you say, because this is 2014, unless you assert that the resident was changed, we have to place our reliance on this electoral roll.
This entire, you lords, you can see this Anganwadi center area, it starts.
And your verification report is also not against her, the writ petitioner.
Yes. Page,
Just read it carefully.
page 32, my lord, vacancy.
Read
Page
it.
32, these are the list of houses which fall within the Anganwadi center area of Hilung 3. There, the name of the family of the appellant does not find place. And this list consists
But a
of
parallel document, which is usually believed because the home-to-home survey is made, because they have to identify the booth against the voter. So therefore, why should you disbelieve this document?
Well, this is home-to-home survey. After home-to-home
No,
survey,
electoral roll is also prepared after home-to-home survey.
this list consists of 85 persons.
Page 48, the date of the document, my lord may kindly see. It's also 2014. The date of the survey, your lordship would see, page 48. It's 8/9/2014. The ground of argument against me, which is being taken that the electoral rolls of 2014 have been produced. The lordship would kindly see the date on which the survey has been conducted. It is not confirmation of my appointment.
No, that is pursuant to the direction of the appellate authority.
Say report of the man. That is not report. That is report by Prayasin Singh. This report was by another land.
From the voter list, how can we decide Hingula 1, 2, 3?
That is the man. That's from a way to take that. On verification, 10 parameters. On verification of the subdivision preferred by the city court for Anganwadi provision number report of Anganwadi worker.
Let us see.
As per the creation of city court, they are feeling that Pramila and Pratya are not resident.
You also come to annexure 11, page 49 of the writ petition. There is another communication from the additional district magistrate of Subarnapur.
13. Response to letter dated 7/6.
He was earlier also serving on the Island 3.
Yes.
He was initially given appointment. Thereafter, her selection was challenged by the present respondent number 4. Well, he challenged in the writ petition before this honorable court. Ultimately, he was directed to prefer appeal.
File the appeal, but the
Appeal was allowed.
verification was carried out when?
My lord, after selection, my lord. The challenging his her
During the
selection.
period of this appeal.
My lord, I have approached this honorable court and this honorable court was pleased to direct me to ask for the provision if file appeal. And accordingly, I filed appeal. And in the appeal, my lord, the appellate authority, my lord, on the report of the CTPO, my lord, since I have not considered for the appointment, since I am belongs to other service area.
See, there was a factual dispute with regard to the resident of both the applicant. So at page 11, my lord, page 11 top, there was a direction to the CDPO to submit the factual report.
And
Accordingly, this annexure
getting the
10,
report that I belongs to service area.
page
they have
11 top,
appointed
my
me.
lord, we can see. Report of CDPO Biramaharajpur communicated by letter number 690 dated 22/10/2014 in response to district letter number 21/8/2014. So during pendency of the appeal, this report was called for, and this letter dated 22/10/2014 is appearing at page 31.
If I may kindly just show one more document to your lordships at annexure 3, my lord may kindly have page 16. My lord, this is the only document prior to 2014, which is of the year 2012. Your lordship would just see that the next page, page number 17, my lord, it is a categorical finding that I belong to Hilung 3 area. If my lord Justice Ratho would kindly assist me, my lord, in the first 2 lines, my lord.
Page.
Page 17, my lord.
1/7.
Yes, your lordship. A complaint was raised against me. An inquiry was conducted, approved by the PA, which your lordship would find at page 17. After the inquiry, Pramila Bhoi, Antargata Kendra 3 Madhyare, Parisima Bhittare, Antargata Atanti.
Next line, my lord, we can see.
2 number, paper 2 number.
Good.
Who was the member of this verification committee?
My lord, what? My lord, in
CDPO.
CDPO, the authority who has issued the advertisement for engagement.
Child development, my lord.
What has been scored out? Something has been scored out below. What is that?
My lord,
Page 17?
my lord, I
Contrary
can't
view
remember.
was there, that has been.
My lord, I
ସେଟା
can't.
କଣ?
Contrary view ଥିଲେ।
ଏମିତି କଟା ହେଇଛି କିଛି ଦୁଷ୍କର୍ଣ୍ଣି ବି।
ପ୍ରମିଳା ଭୋଇ ଓ ପ୍ରତିମା ଭୋଇ କେନ୍ଦ୍ର ନମ୍ବର 3 ର ପରିସୀମା ଭିତରେ ଅଛନ୍ତି। In the first line stated that they are residing in
ତାପରେ
Anganwadi Center 2. The next line Anganwadi 3.
ସେ ଅନୁସାରେ ପ୍ରମିଳା ଭୋଇ ଓ ପ୍ରତିଭା ଭୋଇ ଦୁହେଁଙ୍କ
ପରିସୀମା ଭିତରେ ଅଛନ୍ତି।
କେନ୍ଦ୍ର ନମ୍ବର 3 ର ପରିସୀମା।
somebody else, both of you?
No,
No, no, no.
Me,
ସେଟା ଆଉ ଜଣେ
me and somebody else, not the
ଅଛନ୍ତି।
respondent 4.
ତାପରେ ଗୋଟେ କଣ ଲେଖା ହେଇଲା କଟା ହେଇଗଲା।
ଆଜ୍ଞା ସେଟା ଲେଖା ହେଇଛି ପ୍ରକୃତରେ ପ୍ରମିଳା ଭୋଇ ଆଉ ପ୍ରତିଭା ଭୋଇ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ପରିସୀମା ଭିତରେ ଅଛନ୍ତି।
ସେଟାକୁ କାଟିଲେ ସେଟା ଭୁଲ।
କଣ୍ଟ୍ରାଡିକ୍ଟରି କାଟିକି ଲେଖିଛନ୍ତି।
Contradictory. They say that ki they're
ସେମ୍ ନା ସେମ୍ ଆଉ ଥରେ ପଢିଲେ ଯଦି ପଢି ପାରୁଛନ୍ତି।
We think that it will be proper that we direct the respondent number 2 to just make a fresh survey because he is the sub-collector of the area.
Yes.
He can decide it and all both the parties, the appellant and the writ petitioner will file all the documents and contention because your party has no case now because you have not challenged the order of the land as single judge.
Single
They're still
judge,
serving.
Though there is some adverse observation in the
No, that the government cannot
my
avoid
appointment
the.
was not set aside. For that reason, I have not challenged.
Sorry,
My appointment was not set aside.
may not be, but that observation.
But my lord, if your lordship go through that,
Why will we go through para? We are
Ma'am,
reading that order and asking you.
that is my lord submission. My lord, if
Submission?
your lordship go through the petitioner is the resident of Ilong 2 and her resident does come on. Thereafter, my lord, first line, my lord. I have the conducting council on the.
That is why, since you are the conducting council, you should have been cautious.
Since my lord, no order against me, so I am not challenged.
Because we find some contradictory records are there.
This annexure
Record
3 itself.
finding.
This annexure 3 itself, two contradictory views.
That is why I am telling you.
Probably that is why this direction was issued by the appellate authority for re-verification.
And re-verification has been made by a person doesn't have any knowledge of the area also.
No,
No, that person has.
CDPO is the.
They are dealing with some other matters.
No, have knowledge, but they're difficult to
They
rely
are
on
not
them.
the local residents.
And
Anganwadi workers are the local.
And CPDU job is something very different. They're handling with this the ICDS projects or PC projects, and they do not know which area and how to measure all these things. The experts are either Tahsildar or the sub-collector.
My lord, actually difficulty is, my lord, the center, the Anganwadi center can be marketed by the Anganwadi worker adjacent to, well, there are initially first in a village one Anganwadi center. That was bifurcated two Anganwadi center. So
there are three altogether in the
altogether.
same village.
So the Anganwadi worker who are working there can demarcate from which street to which street come under which area.
So those persons, according to me, are not a reliable person.
Indeed, your lordship. Bow down, your lordship.
So they go to a very responsible officer in the administration, and they will go and they'll find out.
CDPO is also not reliable.
You cannot deny the fact that the writ petitioner is the most meritorious amongst them. So if it is found,
No. The present petitioner is the meritorious.
Respondent number 4.
4 male. I am the your lordship kind of a glance too.
But I'm seeing the records that say that.
No. Respondent. On the verification of the set. May I read again? Your lordship, page 10, man.
No, what that you are showing.
Page 21.
I am not appointed as a Anganwadi worker since I does not belong to.
No,
that service.
your name was not there in the list because initially they took that you are not there.
Yes.
So what is your percentage? This one is
My lord,
58.
as per my lord, that page 10.
Say it, as per what? Say what is your percentage?
Percentage, my lord, more max, my lord. Is academically more meritorious than the
So
respondent.
that you have not calculated what is the percentage. That also, these mark sheets also vary from time to time.
I am more meritorious than for my lord.
I'm sorry, your lordship may see serial number 3. They were a
Ah.
candidate. Bhumisuta Meher is a candidate 51.66.
That is the why. Come to the page 21. They
Yes,
have
your lordship.
calculated.
This is
Bhumisuta
what,
Meher.
best of 5 or what, rank holding?
My lord, these findings your lordship would see as to what reasons these have been made.
Oh, that was.
Have you calculated the percentage or you've
No,
taken it as they declare the ranks? Best
No,
of 5.
no,
Here
I
it is not that. Here it will be the total marks.
This is the
Total marks
tabulation
plus
sheet. You can
plus
see it. Page
percentage.
Check
21.
and see if it is correct. May have missed that.
Yes, page 21 of the writ petition.
Page 21.
This is a tabulation sheet.
Annexure 3.
Educationally, this respondent number 4 is more meritorious. Your lordship can see page 21, column 12.
Mr. Saurav, have you filed wakalatnam on behalf of the
Madam,
appellate?
on behalf of Mr. Hutta, my lord, I'm appearing, my lord.
Behalf of Mr. Hutta.
Yes, your lordship.
No, this respondent number 4 is a serial number 3 in page
Yes.
21.
Yes. Serial number 3, your lordship can see the marks.
Yes,
Column 12.
51.66.
Column 12, my lord, can see. Column 12 is the percentage of matric marks.
No, this is ultimately.
No, he is getting the present
46,
appellant by virtue of his
46.66.
caste reserve category. He's getting 10% more.
Right.
No,
So
there is a blank.
merit is concerned. Merit is the respondent number 4.
Meritorious means all together. Merit is determined by this way. When there is certain premium has been granted on the basis of the reservation, that has to be included in the merit list.
So that way, if you look, Sabita Bhai had the highest. Percentage, Sabita Bhai had the highest.
Yes,
Then
40.
followed by Bhumi Sutta and then Pramila. Then what was added? CBC.
We are not giving, we just determine on the basis of
Yeah,
this report, you decide finally. We are interfering with the appellate order also.
What it was. This which they have given, you can't read it.
Heard Mr. S. Saurav and counsel appearing to the appellant on instruction of Mr. H. Hutta.
N. Hutta.
N. Hutta. Also heard Mr. P. K. Madhuli, an additional government advocate, appearing for the respondents number 1, 2, and 3. Where is Mr. A. Tripathi and counsel appears for the respondent number 4. Stop. By means of this intercourt appeal, the order why is there only single judge's order? This is not
Annexure 1.
No, this is the appellate authority's order. Single judge's order.
Annexure
1 in read petition.
Annexure
One.
Of the writ appeal, your lordship.
No, Annexure 1 to the writ petition, that is the applied authority order. Order dated 30/10/2000.
Starts from page 9, your lordship.
Of the writ appeal?
Writ
No, writ
petition.
Petition.
No, writ petition, no, I'm learning single judge's order is not. in the
Learning
writ.
single judge's order, may I just pass?
Order dated 6/2/2015. Delivered in WPC number 23683 of 2014 by the learned single judge. By means of the said order dated 6/2/2015, and a single judge has observed as follows. Subpara quote. Both the petitioner and OP4 were aware that they are not residents within the service area of center number 3 of Highland. There are 3 Anganwadi centers, and accordingly, the applications for the appointment of 3 Anganwadi workers have been separately invited. The petitioner is the resident of Highline 2, and her residence does not come under the service area of Highline AWC3 Anganwadi Center. In the view of the matter, the appellate authority did not find her suitable for Highline 2 Anganwadi Center. Subpara. On perusing the impugned judgment and considering the submission made, I do not find any infirmity in the impugned order, unquote. Having observed thus, the writ petition has been dismissed. Stop. The writ petition being WPC number 23683 of 2014 was filed for challenging the order of the appellate authority
Page 9,
dated 30/10/2014 in AWW case number 10/2019. 2013. By the said order, it was held that on verification of certificate and mark sheet, it can be seen the said writ petition was the respondent number 4 was academically more meritorious than the respondent number 1, who has secured 350 marks out of 715 in high school certificate examination and 400 marks out of 600 marks in annual higher secondary examination certificate within bracket arts, and placed in the second division and first division respectively. It is well worth of special mention that appellant had experience of working as Asha Hailam under CSC, Birma Haraj Rajpur since 1/8/2007 till 33/2018, which was communicated by the letter number 238 dated 33/2012 of the medical officer / ICCSC Birma Harajpur, and also by the CPDU, the same Birma Harajpur. Stop. According to us, this observation was not very relevant, considering the very focused challenge that whether the REIT appellant was a resident of the Highland, residents of Highland area, resident of area of Highland 3 or not. Stop. It has been observed in the order dated 30/10/2014 that the selection of respondent number 1 as AWW of Highland Center 3, AWC is illegal and arbitrary, as the respondent number 1 doesn't belong to the service area of AWC-3 of Highland Village, which is prerequisite for selection of AWW. The applicant must be resident of the service area in one of the essential qualification which is required to be fulfilled as a statutory requirement. It is clearly evident from the verification report that AWC area of Highland 3 has been well defined and the respondent number 1 does not belong to AWC area. Her application should have been rejected at the preliminary stage. Stop. The CPW and other members of the selection committee had committed deliberate lapses and gross irregularities by selecting respondent number 1 as AWW Highland 3 Center. At this juncture, we may note that what has been referred in the order dated 30/10/2014 as the respondent number 1 who has been referred is the writ petitioner. So the writ petition is filed as the engagement of the writ appellant, within bracket the respondent number 1 in the appeal being AWW case number 10/2013 was declared illegal. Stop. We have already noted how the learned single judge has dismissed the writ petition. We are constrained to observe that there is no discussion about the grounds taken in the writ petition to challenge the finding of the appellate authority, which passed the order dated 30/10/2014. Mr. Shore of Learned Counsel, appearing with the appellant, has submitted that the finding of both the appellate authority and the learned single judge are dehorsed the records as has been produced in the writ petition. Mr. Shorov has persuaded us to look at the voter list. Stop. It has been shown from the voter list that voter list annexure 4 to the writ petition that the area as demarcated for Highland 3
Voter list there is no Hilung 3.
No. Highland 3, just please, when I declare.
Lordship permission.
Highland 3, in the advertisement number 147 dated 26/3/2021.
Lane reference start, page left side.
It is a one page is this advertisement is a
Lordship permission. The voter list, no Hilung 3 is there.
Hilung 3.
It is for Hilung, village Hilung.
As the quote, school Shahi. This is the word is a school Shahi.
School Sahi is the area near the school. From School Sahi of
Krishna Mahakur
Ramakrishna Mahakur to Jogendra Mirda.
To Jogendra Mirda. According to Mr. Saurav, from the page for the serial 4 to 8. Page 18 for serial 4 to 8. Then make it page 18 of the writ petition. To serial
500, page
500, page 20 of the writ petition. At the area which has been defined as Highline 3. Stop. The appellant's residence within that area, and for that purpose, Mr. Saurav has shown that the appellant's name appears in serial number 495, page 10 of the page 20 of the writ petition. Stop. It is very difficult to demarcate the area from a voter list. At the same time, the verification, where is the verification? You have referred it?
Page
report of the
32, Your Lordship. Page 31, Annexure 10, enclosing the report at page 32.
Yes. And from the verification report, Annexure 10, to the writ petition, also it cannot be deciphered and how and following what method the petitioner, the writ appellant has been declared not the resident of Highline 3. Stop. In this stop, it may be also noted that initially the writ appellant was accepted as the resident of Highline 3, and he was also given the appointment to the Highline 3 Anganwadi Center. The respondent number 4, initially by filing a writ petition, challenged the said engagement, but later on, she was advised to file an appeal before the appellate authority. Stop. The order dated 30/10/2020 such and such was passed in the said appeal by declaring the appointment engagement of the appellant, writ appellant, is illegal as she doesn't live within the area relevant for Highland 3. Stop. We have found some documents about the residence of the writ appellant, but according to us, neither the verification report nor the voter list is the substantive piece of document from where a read court can come to a definite finding about the area. Even the finding of the appellate court is highly mechanical, and there is no appreciation how the appellate court has reached to the finding that the read appellant is not the resident of the Highland 2-3 area. So at least the verification report is not very categorical in as much as when a particular place are to be located in the report, it must be shown what kind of method they have used and what are the materials or the records they have considered for such exercise. Merely child development project officer is the officer who have acquaintance with the area. His or her report cannot be treated as a reliable report. As such, we have also considered the tabulation sheet of the selection committee. By applying the various factors according to the guidelines as adopted for the selection of the Anganwadi worker, the read appellant has been adjudged the best candidate. Though Mr. A Tripathi London Council appearing for the respondent number 4 highly contested this contention of Mr. Saurav. According to him, it would be apparent that so far the merit is concerned, the respondent number 4 is the most meritorious candidate. The read appellant has been shown as the highest, has shown to have secured higher score only after adding the special marks as the scheduled caste candidate. Be that as it may, there was no dispute relating to the relative merit. The dispute is entirely, the mainstay of the dispute is entirely on the question of the area of residence, the location, which is essential requirement for engagement as Anganwadi workers. Faced with such circumstances and having heard Mr. P.K. Madhuri, a traditional government advocate, we are of the view that the district sub-collector is not district sub-collector, only called sub-collector. The sub-collector Birmha Maharajapur will be the competent person to make a report to the appointing authority whether the read appellant, namely Romila Boy, is a resident of Highland 3 area for purpose of engagement as Anganwadi worker within the AWW. Stop. Having observed this, we set aside the orders of the London single judge dated six. What is the
30-10-14.
Huh?
30-10-14.
No, 3010 is the appellate court's order.
Single judge number 6/2/2015.
6/2/2015. And the appellate court's order dated 30/10/2014 passed in such and such AWW case number 10/2013. Stop. We direct the respondent number 2, the sub-collector Birham Rajpur, to complete such inquiry, local inquiry, within a period of 15 days from the date of receipt of a copy of the order from the writ appellant and forward the said report to the appointing authorities, the CPW, no?
CDPO.
No, my lord. Chairman is the sub-collector, madam.
Sub-collector.
Sub-collector Bidmarajpur would be
The
the,
chairman of the selection committee.
Then we do the additional district collector.
Your lordship may be pray. Your lordship may send it to appellate authority who has heard the appeal.
No. Then you are aggrieved, you file such a further step. We direct the additional district magistrate, huh?
Yes, madam. District magistrate.
Additional district magistrate, not the sub-collector, huh? And complete within 15 days. So up to the completion of the local inquiry regarding the
my lord, additional district magistrate is the one who has passed the appellate court's order, my lord.
problem is that these both are the interest in the
ADM,
orders.
yes, your lordship. ADM is the
Your
authority.
lordship may send it to district magistrate.
Or
Collector.
district magistrate. Sonpur to complete the local inquiry and submit and send a copy of the report to the sub-collector Birhamrajpur, who is the engaging authority of Anganwadi workers. On the basis of the said report, the engagement of Anganwadi workers be finalized. Stop. In terms of the above, this appeal stands disposed of. A free copy of this order be supplied to Mr. P.K. Muduli, learned additional government advocate for onwards transmission to the district magistrate Sonpur. Urgent certified copies of the grant.
May I pray one thing, my lord. Till a decision taken, the petitioner shall be continued in the postman.
Respondent number 4.
Respondent post.
Till the local inquiry is completed, the respondent number 4 shall be allowed to continue in the site post so that the services to the children are not disrupted.
We are obliged. Your
All
lordship.
right. The district magistrate will conduct an inquiry so far as the residence of appellant is concerned, or
Yes.
both the parties.
No, appellate.
No, there is no dispute.
Only the appellant.
About her, there is no dispute. About her residence, only the writ appellant.
My lord, in terms of 2014, my lord, that 2014, the area,
In terms of the advertisement number that I have given.
the advertisement is of the
Advertisement
year.
number 147 dated 26
2012, madam.
2021. Annexure,
Annexure 2,
annexure 2 to the writ petition.
2012.
The inquiry shall be carried out. Yes, next, call the next
Grateful, your
matter.
lordship. 43.
Yes.
Pardon to mention, madam.
Object, these defects are not removed.
43. 43. Sorry.
Just wait, these are fixed matters.
May it please, my lords. My lords,
What is the essay of status quo notice?
my lords, I'll just,
Status quo notice was sent to someone.
my lords, I'll appraise this court, my lords. My lords,
Yes.
the present appellant since annexure 8 in 2019 has been continuing as Anganwadi worker in the said post. It's by virtue of the impugned writ application, the impugned order, impugn order, the position of the appellant was set aside by this honorable court. Challenging that impugn order at Annexure 11, the present appellant has moved this honorable court, and this honorable court has been pleased to protect the service of the appellant. But a preliminary counter affidavit has been filed.
Yes.
Purportedly deciding the scope of this writ appeal, my lords. Right. Before that, my lords, I would beg to take this honorable court to few previous writ applications pursued by both parties, my lords. If my lords would first peruse Annexure 1 at page 20. My lords, initially, the germen of the dispute is that both the appellant and the respondent number 4 contested for the post of Anganwadi worker.
Yes.
For that particular village, during the process of selection, the appellant challenged the residence of the respondent number 4 before the respondent number 3, who is the CDPO, stating that the respondent number 4 is not a permanent residence of that area where the position for the Anganwadi worker is being selected. That was not considered by the respondent number 3. Challenging the non-consideration, the appellant moved this honorable court, and Annexure 1, page 20 is the first order with regard to the present dispute. My lords, the relevant portion is at page 22. I'll just go to 3-4 orders. Page 22. This honorable court observed that since the collector of the district is competent to decide the matter, I dispose of the writ application directing the opposite party number 1, who is the collector therein. Opposite party number 1 to consider the representation with reference to the records and allegations made by the petitioner in the writ application. If necessary, the petitioner and the selected candidate may be given opportunity of hearing. This exercise is to be completed within a period of 2 months from the date of communication of this order. My lords, thereafter, my lords.
Yes.
The learned collector was pleased to reject the contention of the present appellant. The learned collector held that the contention of the appellant holds no water.
This is the
first round of litigation.
Yes.
With regard to the present Anganwadi center.
Yes.
My lords.
So what was the report of the collector?
My lords, that's at Annexure 2, my lords.
Annexure 2 of the present writ petition?
My lords, Annexure 2, page 23, my lords, of the appeal memo.
Appeal memo?
Yes, my lords. Did my lords find it?
Page 20?
23, my lords.
Okay.
The relevant paragraph will be para number 3. I heard both the writ petitioner and the successful candidate on 15th of September 2006. During hearing, the writ petitioner is not able to substantiate the allegation on payment.
Illegal gratification.
On illegal gratification by the successful candidate. As to the genuineness of the residential certificate submitted by the successful candidate, it may be stated that the certificate issued by the additional Tahsildar Paikamala was produced in original. While the genuineness of the certificate is not disputed, the writ petitioner says that the successful candidate does not stay in the village, even though it is so mentioned. But thereafter, the learned collector writes the guideline. And finally, my lords, at page 25, the learned collector states that in the light of the foregoing discussions, the representation dated 24th September by Aparajita Naik, who is the present appellant, is rejected as there is no sufficient ground to interfere with selection, my lords. As things stood thus, my lords, challenging this order of rejection by the learned collector, the present appellant again moved this honorable court, and that order is at page 26, Annexure 3. It's page 26 of the appeal memo. Page 26 is the writ application by the present appellant challenging the order of rejection of the learned collector.
What is the order?
My lords, page 26, annexure 3, the relevant page is at page 27. My lords, initially, when the appellant pursued this writ application, this honorable court protected the appellant, but eventually this honorable court was pleased to dismiss the writ application with an observation at para number 3.
Yes, yes.
My lords, the collector relying
on the basis of this certificate issued by the Tahsildar.
Yes, my lords,
Collector
I'm just
decided it and
reading
that
one
certificate
relevant line.
was not challenged by.
Yes, my lords. My lords, this honorable court said that since the residential certificate is not under challenge, we cannot dispute the genuineness of the residence certificate. As things stood thus, consequent to annexure 3, the order of refusal by this honorable court, the appellant moved in appeal, challenging the original residential certificate issued in favor of respondent number 4. And that was registered as, my lords, appeal case number 2 of 2013.
Where is that order? Appeal case
My lords.
number order?
That order, my lords, would find at page 32 at annexure 5, wherein the learned appellate authority, page 32 annexure 5.
Yes.
It's wherein the learned appellate authority was pleased to hold that incorrect residential certificate has been issued. I would take my lord to page 36, which states the findings by the learned appellate authority. It's page 36 of the appeal memo.
What is the basis of this observation?
My lords, two findings which my lords may kindly peruse at page 36.
Is
page 36 towards the bottom, my lords would have a perusal to point number 5 onwards. But did my lords find it? My lords, page 36 towards the bottom, point number 5. That's the findings of the learned appellate authority.
Page 35, I think.
35 is where the order.
All right, 36.
Minutes.
You are referring to?
Sorry, my lords.
You are referring to point number?
Point number 5 at page 36. But if I may read it, my lords.
Point number 5 is regarding the application for that post only. Findings number?
Is my lords at running page 36 of the appeal memo?
We are looking into that.
Well, it's then page, it's the findings. At point number 5, it says it's a fact. Did my lords find it?
No, it's a fact that she applied for the AWW.
Yes, my lords. Yes, my lords.
What is the basis of cancel? Just holding that
now the basis is at 7, 8, and 9.
All right.
But now because 5 and 6 are prequel to 7, 8, 9, my lords. My lords, 5 says it's a fact that both the appellant Aparajita Naik and respondent Dhanmat Naik applied. 6 says that Dhanmati Naik, who is the respondent number 4, is married to Khirasagar Naik of village Bhen Sadhara.
8 and 9 is relevant. You read only 8 and 9.
My lords, it's a fact that Dhanmati Naik is mentioned in the voter list bearing serial number 845 in 2004 and 5, 846 in 2006, 819 in 2008, 851 in 2007. And likewise, 9 is the voter list of her husband. Now, my lords, 10. The next page, my lords. 10 says that it is a fact CDPO Jharkhand has supplied RTI to Akshay Kumbhar with a letter number so-and-so regarding birth, immunization, and survey report of family members of Khirasagar Naik of village Bhainsadhara. 11. The same thing, my lords. the medical officer CHC provides RT information regarding birth and survey report of Dhanmati Naik of village Bhaisadhara. It's 8, 9, 10, 11 of the findings by the learned appellate authority shows that
Who has carried out that survey?
my lords, point number 12.
No, point number 10, there is a reference of the survey report.
My lord, survey is usually done by the local revenue inspector. My lords.
No, there is no mention.
My lords, basing on this, my lords, basing on these findings, my lords, the learned appellate authority was pleased to set aside the residential certificate issued in respondent number 4. Well, by that time, my lords, respondent number 4 was in service in the Anganwadi center.
Yes.
But thereafter,
yes. Please proceed. Huh?
My lords.
Please proceed.
My lords, my lords. My lords, as things stood thus, when the residential certificate was rejected in favor of respondent number 4, my lords, 2 writ applications arose. One by the present respondent number 4, challenging the legality of the order on the question of limitation on the ground that since they are challenging the certificate of 2005 and 2013, the question of limitation was not properly dealt with. The second round of writ application was filed with the present appellant on the ground that despite the residential certificate issued in favor of the respondent number 4, the position should have been vacated and declared vacant by respondent number 3, and she should have been given the appointment. The 2 writ application was filed, my lords. My lords, with regard to the writ application filed by respondent number 4, this honorable court was pleased to remand back the matter for fresh adjudication on the ground of question of limitation, my lords. My lords, that order sending back, remanding the matter, my lords, is at Annexure 6, page 38.
This is the order of the writ petition.
Yes, my lords. Wherein this honorable court, my lords, that starts at page 38. The relevant part is at page 39. Wherein this honorable court observed that it should be sent back for fresh adjudication. Yes, my lords, having page 39.
Yes.
My lords, last 2 paragraphs are this matter is remanded back to the learned sub-collector Padampur for disposal affirmation merit, taking into consideration the question of limitation properly at its proper perspective. The parties are directed to appear before the sub-collector on so-and-so date. The matter may be disposed of as expeditiously as possible, preferably within 4 months. And this is the outcome of the matter preferred by the respondent number 4, my lords. But with regard to this another round of writ application preferred by the appellant, my lords, this honorable court at Annexure 6, page 40.
Yes.
Disposed of directing that the appellant should be given the post. My lords would find the relevant observation at page 43 under paragraph 5. Page 43, paragraph 5.
Paragraph 4.
Minutes 4 is the submission of the State Council. 5
Yes,
is the. Should I read 4 or should I read para 5? What's
okay.
Minutes para 6 also. This honorable court has held that it should be given to the present appellant, minutes. The consequential effect of Annexure 7 is Annexure 8, my lords.
So this engagement letter has been issued?
My lords, page 8, Annexure 8, page 45. And the translated copy is at page 46. The engagement letter pursuant to Annexure 7 is at Annexure 8, my lords. And my lords, pursuant to annexure 8, the appellant took over charge of the Anganwadi center, my lords. Since the, sorry.
This is the appointment letter
My
issued
lords,
in favor of?
favor of the appellant, my lords. Page 46 is a translated copy of it. Page 45 is in the vernacular language. Page 46 is a translated copy. Wherein the opposite party number 3 has asked the appellant to bring relevant records and join for duties under the Anganwadi center, my lords. My lords, annexure 9, the next page, after the remand by this honorable court under annexure 5, so annexure 6, my lords, annexure 9 is the rehearing of the appeal case wherein the appellant has challenged the residential certificate of the respondent number 4, my lords. My lords, at page 48, the learned appellate authority discussed the delay caused in filing the appeal in detail. Page 48 and 49 is how the appellant has explained what caused the delay in filing of the appeal. Page 50 are the relevant judgments on which the appellant relied before the learned appellate authority to explain her delay. Well, considering the documents that have been resubmitted before the learned lower appellate authority, as well as the case laws, the lower appellate authority, my lords, at page 52,
yes,
page 52, my lords, came to a conclusion that I am inclined to pass order that this court has not committed any mistake while passing the order of condoning delay in filing the appeal. Hence, the final order passed on 13th January 2015 in this appeal case is upheld. My lords, this remand order is upholding the initial order rejecting the residential certificate issued in favor of respondent number.
Maintained.
Sorry, my lords.
It is maintained, not upheld.
I'm so sorry, my lords. It is maintained, my lords.
Yes. That what is the provision for the limitation for filing appeal?
My lords, rule 8.
Just read that rule. I am not very acquainted.
My lords, before my lords read rule 8.
Just at this stage, since we are now looking at the observation relating to the limitation, let us read rule 8 of
Odisha Miscellaneous Certificate Rules 2019, my lords.
You just please read this rule.
Rule 8 starts with cancellation of certificate.
Yes.
If any certificate is granted wrongly for any reason other than wrong declaration by the applicant, as mentioned under Rule 6 subclause 8, the revenue officer shall bring it to the notice of his next higher authority, who shall then proceed to cancel the certificate and pass orders for revocation of the benefits that might have been acquired by the applicant, provided that no order shall be passed without giving the person concerned a reasonable opportunity of being heard. Rule 10 is appeal.
Just a minute.
Sorry.
So the 3 months is the period. All right. Then
Rule 10 is the appellate provision. Rule 10 is the appellate provision.
That we have seen. But the limitation period is 3 months.
3 months. May I proceed?
Yes, continue.
After the original order was maintained by the learned appellate authority, my lords, thereafter, the present respondent number 4 filed a writ appeal, challenging the order.
Writ appeal.
challenging the order of the Honorable Single Judge, wherein the appellant was, wherein the respondent number 3 was directed to give the appointment to the appellant. In writ appeal, the respondent number 4 challenged Annexure 6. Annexure 6 has seen is the order wherein this Honorable Court was pleased to hold that the appellant should work as Anganwadi worker, my lords. Annexure 7 is pursuant to Annexure 6. Writ appeal was filed by respondent number 4.
Yes.
With this Honorable Court, in writ appeal, writ appeal is at Annexure 10, page 53, my lords.
Yes.
Writ appeal was dismissed by the this Honorable Court with an observation that observation is at page 58 under paragraph 3, my lords.
Under paragraph
3, my lords.
What is there?
Additionally, it is seen that there is no dispute that last date of filing application pursuant to notification dated 5th February was 15th February 2005. Annexure 2, the residence certificate was issued on 6th of May and the document has been cancelled. First, we could not understand how application filed on order before 15th of February could be accompanied by a certificate issued on 6th of May. This is context with respondent number 4. Moreover, the said certificate has been cancelled in the meantime and that a writ application is pending before the court challenging the order of Sub-Collector Padampur. No order of the stay has been granted. So at present, as matter stands, there is no certificate in favor of the appellant showing her to be the resident of Dudki Dadar. But Dudki Dadar is the name of the Anganwadi center, my lords. Resident of Dudki Dadar, and we come to the conclusion that the order passed by learned single judge is correct and has been delivered in its proper perspective, which requires no interference, my lords. But at this juncture, I would humbly state, my lords, by virtue of this order of dismissal of the writ appeal, this Honorable Court has not only confirmed the appointment of the appellant under Annexure 6, but also the original order of 13th of January, wherein the residential certificate has been rejected in favor of respondent number 4. In other words, my lords, the original rejection order, the order of the learned Honorable Single Judge in the writ application has been confirmed by the Honorable Division Bench. As things stood thus, when the order rejecting the residential certificate of the respondent number 4 has attained finality, the respondent number 4 filed another writ application challenging the order of the learned appellate authority wherein it maintained the original order, which is impugned before this Honorable Court in this present appeal. The interesting aspect is that in that writ application, which is impugned before this Honorable Court, the respondent number 4 did not bring the aspect to the learned Honorable Single Judge that a writ appeal has been dismissed.
What is the order? This 25/1/2023.
My lords,
Annexure 11.
11 is the impugned order, my lords. Yes, my lords, Annexure 11. My lords, now Annexure 11, my lords, at page 63, my lords. 62, my lords. It's a relevant portion. But in this, the appellant would fairly submit that although she had entered her appearance, she could not be represented to contest the writ application, my lords. But be that as it may, the humble submission of the appellant is that had the factum of dismissal of another writ appeal, wherein the original order of rejection of the residential certificate been confirmed, would have been brought before the Honorable Single Judge, the Honorable Single Judge would not have proceeded the impugned writ application on the aspect that under Rule 6, the appellant could never have filed an appeal cancelling the residential certificate. But in other words, the writ application was ported before the Honorable Single Judge that there is no order confirming Annexure 5, which is the original rejection order, and that the only point of adjudication before the Honorable Single Judge was whether the appellant in the first instance could have maintained an appeal at all. Hence, an observation at para 5 in page 63 by the Honorable Single Judge was passed, wherein the Honorable Single Judge held that submissions made by Mr. Rath are accepted. Aggrieved person referred to in Rule 8 can only be an unsuccessful applicant under Rule 6. In such view of things, it is not necessary to adjudicate on limitation, and hence the impunity is set aside. It's my humble submission is that once the original order of rejection has been upheld by this Honorable Court in a writ appeal, the same is now not available for adjudication, giving it another form in a separate writ application. The earlier rejection by the Honorable Division Bench should have been brought in this impugned writ application.
Yes.
That is the crux of my submission before this court. But now a preliminary counter affidavit has been filed on the observation by she could not have challenged, but the entire factum of the dispute is that the residential certificate is very important and germane to decide as to who would get the appointment as an Anganwadi worker. And it is unfortunate that the appellant could not appear. But had she appeared and had this factum been brought to this Honorable Court, that the original rejection.
So in this writ petition, the respondent number 4 was the writ petitioner.
Sorry, my lords.
The writ petition is a 7035.
My lord, 70. And interestingly, my lords, this writ application.
Just wait.
Sorry, my lords.
7035 of 2018. The respondent number 4 of the present appeal was the writ petitioner.
Yes, my lords.
Right?
Yes, my lords.
So your contention is that the respondent number 4, while filing this writ petition, suppressed the order of the division bench, which affirmed the order of the learned single judge in the earlier round of litigation.
My lords, and additionally, my lords, this writ application was filed only after the dismissal of the writ appeal. By that time,
give the dates,
my lord,
when it was filed.
My lord would also find the date. I'm giving the date, my lords. My lords, the impugned order was on 25th of January 2023. It's the impugned single judge order.
No, not impugned order, the 25th January, when it was filed.
My lords,
you said after the decision of the division.
My lords, the decision of the Honorable Division Bench came on
1st March, it appears, I don't know, this 1st March 2023, this, no, how can it be?
My lords, I'm just submitting, my lords. My lords, the date on which the decision of the Honorable Division Bench came.
I am asking you a straight question, when this writ petition 7035 was filed. This is a very material date.
My lords.
Page 60.
Page 60,
my lord. 24th April 2018. There is seal that presented in court. Left side, my lord. Page 60.
Page 16.
Left side column, my lord. That the seal is there when the matter was placed filed in the counter. Presented in court 24/4/2018. Left side.
It is not 24/1.
24 April.
24
April 2018.
My lords.
All right. And the decision of the division bench?
My lords, 6th of
March 19.
6th of March 19.
6th of
March 2019.
2019. We'll continue tomorrow.
Tomorrow
Tomorrow it marking parted. What is your good name?
My lords, Swayamjit Raut, my lords.
Yes, Raut.
My lords.
And Mr. S. Raut, Learned Counsel. Appealing for the appellant in part for continuation of the hearing, list the matter tomorrow. Give a date on tomorrow's date. And Mr. Who is
Chamber 1 to 3.
All right, Mr. M.K. Puntiel, an additional government advocate, appears for the respondents number 1 to 3, and Mr. D.N. Rath. You are Mr. Rath.
My lord.
Learned Counsel appears for the respondent number 4.
Lordship,
Tomorrow 2 p.m. or
Yes.
Your Lordship, I may pardon, Your Lordship. Item 15, which has been passed over, Your Lordship. It supposedly it cannot be taken up, Your Lordship. Kindly be taken up tomorrow morning. Tomorrow. Item.
Not 2 p.m. The other general list.
Your Lordship, in usual course, Your Lordship.
We fix on the 20th, much better. 20th July.
Your Lordship, it's urgent, Your Lordship.
Why? What is the kind of urgency? 20th July, only 3 days away.
Lords, actually, this is regarding the promotional exercise which is being carried on in
20th
the
July,
place.
Mr. Nanda.
20th.
This July 20th. 3 days after. All right, 20th July.
In the usual normal as fresh admission as today's.
All right, we'll see on 20th July.
Item
number
26, my lord.
Ah.
26 was passed over. Mr. Mishra, he requested me that let be taken up tomorrow.
All right, give it tomorrow.
28, my lord. And item number 57, my lords, it was fixed at 2 p.m. It's not called.
No,
That's a-
because this matter I have taken up,
It's-
this, that on the 20th we tried. 20th, all right, 20th. 20th, that matter is not there on 20th. Is a no, commercial appellate division. 20th. Then 21st. It will come on 21st.
21st at 2 p.m. my lord.
At 2 p.m. Oh. On 24th, because cannot. be-
Arbitration bench would function.
Arbitration bench should be there. 24th.
And 28,
Item, in
item
same
28,
item,
my lord.
item 26, I've already filed my response, my lord. That may be taken on record. my lord. I've submitted.
Filed where? In the
I've given it, handed it over to the court master. my lord.
No, you just do one thing, since
I'll
matter will
file
be
it in the
ta- you
registry.
file it, take it back and file it
My
in
lord,
the
my-
registry.
My lord.
Right, item 28, my lord. That Konark Temple matter, your lordship has passed over. Oh, today I am filing an additional affidavit, learned counsel for the Archaeological Survey of India. They have also filed counter affidavit. They fix a date, lordship. Fix any
Lordship,
date.
I was served with a
Which item did
copy.
we pass over, Mr.
28.
Das?
28.
Was it passed over? It hasn't been taken up, I think. Passed over?
Passed.
The archaeological survey was supposed to file an affidavit.
They have filed today.
So I just was served with a copy. So I need a couple of weeks to react to that.
And my lord,
10th of
the
August,
My lord,
28.
10th of August,
10th,
10th of
2nd of August.
2nd of August,
2nd of August.
Yes.
or little later, my lord, 5th or 6th of August. 10th.
The situation is not
First
good, my
up,
lord.
first
They're
up.
the
situation, they're
What is it?
creating
Public
chaos.
interest.
Well, it's only 10th, 11th and 12th of August. I am not in town.
Any day prior to that.
2nd August, you are fixing the
Yes.
matter. Please
Second
try
of-
to file your
Great.
response.
Yes.
Item number 42, my lord.
What is your item number exactly? 28. 28.
Well, item number
Item
47.
number 42, my lord.
Ah.
The interim order is against me, my lord. I pray, my lord.
42 already, that will take up on 31st July. 31st July.
And the interim order may continue.
Interim order is passed, shall continue, huh? Just give a note.
Well, item number
Item number
47, the
51,
gratuity
Lordship.
matter. In
Lordship,
the
this
review,
is
it was
the-
dismissed. Despite
This
that,
is the second
the
round of
interval is,
litigation, Lord.
47, maybe taken up tomorrow.
Tomorrow the list is highly congested.
Malad,
What is the urgency?
or this is a non-paper gratuity for 9 years. despite the dismissal of the review petition by the employer, there is an observation for expulsion of that I filed the writ appeal. The review petition was dismissed on a single judge, giving a so-called liberty to the employer to file a appeal after 9 years. Although the statute provides only
This
4 months.
27th.
That
We are
expulsion.
fixing the
for
matter on
expulsion of that, I
27th.
filed this violent.
27th of this month, July.
Lordship,
Lord,
item number
item
51,
26, my
Lordship.
lord, learned senior advocate Mr. Mukherjee had made a mention. So it has been fixed to tomorrow. So the response cannot be, if I file it in the registry, my lord, it.
All right, you just do it tomorrow. Ask the registry, the matter is fixed
Ma'am.
tomorrow. If they cannot supply, we'll bring it after the matter is recorded.
Item 51, Lordship. This is Lordship second round of litigation. In the previous writ petition, Lordship disposed of after making some arrangement. But Lordship, the husband deliberately violated that, Lordship. Lordship, it's, last time I have also made.
Day after tomorrow. Day after tomorrow. we'll
Lordship,
take up.
one humble submission is that can it be come, Lordship, after admission, Lordship? Always it is listed
No,
after.
you just mention day after tomorrow. Today we will not mention. You mention and the mention hour day after tomorrow. We'll upgrade the matter.
No, Lordship, this is 51. Today's item number 51.
I'm telling you, if you want the hearing that you mention the matter in the mention hour to upgrade the this matter. All right.
Item 36, my lord. Item 36 may kindly fix a date. I am for the respondent employee.
All the matters dates will be given. Don't worry. Give a date on this fixed date, all the matters. Repeat the present, this water matter, last matter. Is there any other bench? So wait 5 minutes for the full court meeting. Oh, chamber matter.